My lord, last Thursday, it was directed to the court officer to club together all the EZCC matters. 3 matters were listed, but my number is not listed. Those succeeding numbers are listed. So,
but the file is in the court itself. The file is in the court itself.
We'll take it up. When we take up the other EZCC matter,
yes,
your matter could not be listed because according to our officer, the department has not sent your application to us.
yes,
Whether it is sent or not sent, we are looking for it. Otherwise, when we take up the EZCC matters, we will take up your file on the days list.
on the
Days list.
okay.
Means it will be heard together.
Uh,
So now you can relax.
okay, thank you. Sir.
Yes.
Obliged, sir.
Yes,
My
yes,
most
sir.
obliged.
May I have your lordship's kind leave, my lord, to seek your lordship's leave to file an appeal
Yes.
without certified copy first thing. Secondly, my lord, your lordship need to fix a date. Otherwise, my lord, on the short notice is there. I want to move it immediately.
What is the matter
The
about?
matter is, my lord, 36,000 primary teachers, they have been sacked by one order. That is matter. That is, my lord, that of great urgency.
Yes,
in that matter.
leave granted. Take the
Kindly fix a date. Otherwise, my lord, short notice.
you ask your learned junior to write the urgency. We must follow the protocol.
Yes.
Write the urgency, we will give a date.
I cannot file it unless a date is given because they will not accept short notice. Filing is not allowed.
No,
Kindly.
you take leave to file and then you take the date from us and give a notice. First you take the leave to file it and then take a date from us.
We have to, I am told, my lord, that we have to write it here. The date has to be mentioned.
Mr. Atul Bishas has taken a leave earlier. You take a normal leave to appeal.
No, my lord, if your lordship grant leave, my lord, I can file. But my lord, I have to wait till 4, my lord, after a queue, my lord.
So that you file and you give a date. We will give a date by 4 o'clock to you. You file it and give the number.
By
Forward.
4 o'clock.
We'll give a date to you after at 4 o'clock. We have to follow the protocol as far as all other matters.
We
We will follow the protocol.
Kindly permit us to file it offline.
Whatever it is. Achhe niyam, yeah, offline.
Offline and with deficit court fee. Court fee is not available.
Yes, take it.
I'm
All that permission is granted. Come back after the filing, write an urgent slip, take the date in the evening.
Yes. My lord, I will be praying, my lord, if it is possible to for your lordships, kindly take it up tomorrow.
We will look into the urgency.
My lord, on a similar prayer, my
And
lord,
please attach the
Instead
server
of tomorrow,
copy
my lord,
with the
kindly take it
mentions.
up day after tomorrow.
my lord,
But
with your kind sanction, my lord, on a similar
Shogota Mitra is waiting before you. Let him mention, you come back.
My
Mr.
lord,
Tiwari is
applicant-
waiting even before that. Mr. Tiwari, you're waiting for a mention. Mr.
This
Panda
matter-
is senior to Mr. Tiwari. Please, let us proceed from left to
I'm
right.
sorry, my lord. Item number 8, my lord.
Yes.
8, my lord. I missed the bus on the last occasion. If your lordship takes up this matter any day before vacation, my lord. Any
Eight.
day, any time.
Item 8.
Item 8, my lord.
We'll see. We'll call it. Try to call it. 8 mention matters.
To mention that.
We'll reach it, hopefully. Let us see.
Today I have not brought the brief, my lord.
Very well. If it comes today, you please mention. Yes, Mr. Tiwari.
Lord, what I am saying, Lord, instead of tomorrow, Lord, that matter, Lord, primary teachers. The day after, kindly take it on day
We have
after.
not yet fixed the date. Ask your junior to come to our court office. We will fix a date and a time. Mr.
Lord, the matter also is being
Mr.
mentioned before the learned single
Mr.
judge, my lord.
Gupta, Mr. Tiwari, we understand the anxiety. We'll give you a date and time. Please check up.
Yes,
We'll see the position in the list and then we'll give you a date and time.
But the situation I am told, my lord, is such
We
that
follow.
I am not appearing for those persons. But my lord, I am hearing constantly, my lord, that they have married, they have got children,
That is
they have aged parents.
we have to thrash it out in court. We'll give you a date and a fixed time.
Lordship,
Yes.
more than that I cannot ask for. Lord, I'm deep.
My lord,
Ask Mr. Atul Bishas not to have a sullen face anymore.
my lord,
Yes.
may I permitted to mention, my lord, applicant lives with his octogenarian mother, ailing mother. And my lord, this honorable court categorically directed that applicants should be allowed to serve his previous station of office, that is Salt office. And my lord,
Give it,
and
give the
you,
state.
yes.
Yes,
Yet, Your Lordship's kind sanction,
Mr.
may I be permitted to allow for mentioning a
yes,
leave to appeal without certificate
Yes,
copy
yes.
on the
granted.
on
Dakut,
the similar matter as Mr. Gupta has submitted, Your Lord.
দেখে নিও ওটা তাহলে yes,
Lord, I am holding the brief on behalf of Mr. Zakir Hossain, Lord. Lord, this matter relating to appointment on compulsory ground, Lord, there is a delay, Lord. I also filed an application, Section 5 of the Limitation Act, Lord.
yes.
There is a delay of 240 days, Lord, filing the appeal, Lord.
Appearing as to be mentioned.
Yes, Lord.
এটা কি to be mentioned? You have copy of the application
yes,
with you. File additional copies. We are not, the application is not being traced. Additional copies, we will take
Lord, I am
that up.
filing here right now.
Have you served on the other side?
Yes, Lord.
Where is your affidavit of service?
I've-
When did you serve them?
In the month of February, Lord, I have served.
You serve on learned advocates, we are giving you permission. And come back again, we shall then, Mr. Panda, you were before the single bench in this matter. They have filed an appeal. Just show him the order sheet. Just show him the order sheet.
Mr. Subhangshu Bandhan.
Oh, you were not before. We are sorry. Then you please serve on Mr. Panda and please serve on Mr. Prosenjit Mukherjee. A fresh notice. And serve them copies of the appeal and the application. Come back as to be mentioned day after tomorrow. Ashun. Namta, write your name. Mr. Parties slash are represented in the order of their name slash names as printed above in the cause title. Full stop. It transpires from the record with two separate order. Same matter
Same matter.
against the same order.
But item number 5 and 6 separate matter, my lord.
Separate. There are 5 here. Full stop. The record that at the application for condonation of delay being Can 1 of 2021 and the application for stay being Can 2 of 2021 are not tagged with the record. Full stop banner. Leave is granted to the appellant to file copies of Can 1 of 2021 and Can 2 of 2021. Full stop. And 2 of 2021. Full stop. Para. File the requisite number of copies of Can 1 of 2021 and Can 2 of 2021 in court today. Full stop. Para. The copies. একটু ওনাকে আসতে কথা বলতে বিমল তুমি চলে এসো তো এখানে ছেড়ে দাও পরে হবে ছেড়ে দাও এখন রাহুল এই কাজটা ছেড়ে দাও কি বললো File 1 of 2021 our court today. The appellant is also directed to serve notice of this order on learned counsel appearing for the respondents before the Honorable Single Bench. And let the matter appear again. Let a fresh affidavit of service be filed on the text. Let the matter appear again under the same heading to be mentioned. Ki Shukrubar রেখে দেখি বুধবার রেখে to be mentioned first of to be mentioned on the 19th of May 2020. Affidavit of service filed today will be taken.
Great.
You serve a notice on learned advocates who appeared before the single bench. File a fresh affidavit of service on the next day. It will appear as to be mentioned on 19th of May.
Great.
I beg to have your honor, please.
Yes. What do you want to be mentioned today, Mr. Tiwari?
Lord, I'm just supplying the copy of the application, my lord. The most probably file is not here, but these are the application.
Yes.
Lord, your lordship, my lord, kindly see the order of the trial court, order of the learned single judge, my lord. That is on 27th of June 2022.
Is there a delay?
No. Delay? No, my lord.
You are appearing for?
I'm appearing for the Kolkata University being led by Mr. Amitabh Chaudhary.
Lord, I am for the state, my lord, led by Mr. Shopun Dutt.
You are ready, Mr. Da.
Lordship, I'm being led by Mr. Amitabh Chaudhary.
That's right, but you are ready.
Lordship, it is appearing suddenly to be mentioned without any notice, Lordship.
Very well. We shall give you an opportunity.
Lordship.
ঠিক আছে হ্যাঁ কম্পোজিশন মানে ইনসেস্ট ডিপিআর অর্ডার চ্যালেঞ্জ করেছে তো ওটাতে এখন কি দাঁড়িয়েছে সেটা খবর নিতে হবে তো দিতে চাইছি ঠিক আছে নেক্সট ডেটে বলে দিচ্ছি
We'll keep it on Friday. Let him let him come prepared to be mentioned Friday on the 19th. Mr. Kumar Jyoti Tiwari, Learned Senior Counsel, appears for the appellant with Tona Namta, Taragato Party Party. Also, the respondents are represented by Uday Namta people. Also, since the respondents complain of inadequate notice to contest this matter, let the matter appear next under the same heading to be mentioned on the 19th of May 2023.
Let the review service be kept on the record.
The affidavit of service filed today be retained with the record. Atar aage hocche oi can jeta bolchilam na পাঁচ
Deeply obliged.
কত
Eight,
সেভেনটা কি হলো
এইটটা জজ সাহেব একবার ডাকতে বলুন।
সেভেনটা
না।
সেভেনটা নট দিছি আপনারা দেখেছেন 7 and 8
এইটটা আমার।
ও আচ্ছা সরি 7 I am for the appellate
in both 7 and 8. In both 7 and 8.
Only seven, my lord. Only seven.
he is
My lord, eight I mentioned, your lordship said that matter would be called on.
Then when do you want it?
My lord, any day before vacation, any time your lordship fixes, my lord. I missed the bus. It was my fault, my lord.
Then come back immediately after vacation on the first day.
If it can be possible, my lord, before vacation, any day, any time, your lordship
Who
fixes.
appears for the other side?
Mr. Shapon Dotto is for that. So I shall inform him
Try your luck on Thursday.
Thursday. I'm grateful.
Mention matter
I'm grateful.
Thursday. Try your luck. Give him a specific notice, Mr. Panda.
My lord.
Give him a notice.
That's it.
Try your luck. Eight. Dakun.
Well, 9, 10 and 11. These three appeals are arising out of similar order, same order.
Tell us which one we have to take up.
My lord, in item number 9, I appear. This is, my lord, with regard
Who
to,
is the appellant?
I am the appellant.
Please come this side.
appellant in the next
Wait,
appeal,
wait, wait.
item number 10.
And you're for the respondent.
Yes, respondent in the two appeals, 9 and 10, and appellant in the number 11.
Then please come this side, Mr. Solicitor General, let them. Auna মামলাটা বার করুন উনি যেটা মেনশন করে
আগে বলবেন না আপনি আপনারই তো আমার বিশেষ তো বলার কিছু নেই।
Who are for the respondents?
তুমি সেটা বলে দাও না।
Please come forward.
আমার পজিশনের জন্য বলছি, তুমি বলে দাও যে যেহেতু আমার অর্গানাইজেশনের অ্যাপয়েন্টমেন্ট আমি আমার পজিশনটার জন্য তুমি এটা বলে দাও।
আপনারটাই তো আমরা নিচ্ছি।
ও আমারটা আইটেম 9 না? ঠিক আছে।
স্যারেকটা বোধহয় নিতে হবে।
The three matters are to be taken up together, 9,
Because
10 and
they
11.
arise out of the same judge.
Therefore, we take them up together, 9, 10 and 11.
Yes.
এটা কেন দিয়েছো? রেখে দাও তুমি। Hello. রেখে দাও তোর সাথে। Let us read the order.
Or may I indicate the gist of the matter first in 2 minutes?
Let us read the order. We'll come back to your gist even after the order. That is the approach we normally try to follow. It helps us.
But this is a long judgment. That's why
We look into it as
this is a
quickly
long
as possible.
judgment, quite a long judgment. 38 pages.
Please take your seat.
Lord, kindly pardon me. The direction is that the appointment already given in the post of director in EZCC
On the microphone.
stands cancelled. The post of director, which is being held since July last year, that appointment is cancelled, and within 2 weeks, the order was passed on 4th this month. Within 2 weeks, a new appointment is to be made from another panel. That's the direction. 2 weeks, my lord, expires day after tomorrow, which means, my lord, unless the order is stayed, at least for a limited period, the appeal will become infructuous.
What expires day after tomorrow?
My lord, day after tomorrow, the appointment stands cancelled, another person joins. Therefore, unless the order is stayed for a limited period, I think, my lord, I did not trouble your lordship with all the details at this stage.
Please take your seat. Few questions to start with, and then you can answer them. Number one, what is the search committee's role? What is the scrutiny committee's role? Number two. Number three, what is the interdependence of the two roles, search committee and the scrutiny committee? Number four, which comes first, the scrutiny committee or the search committee? Number five, whether the search committee can include more names apart from the names filtered by the scrutiny committee. Number six, capacity of the person to recommend names beyond what was scrutinized. And number seven, any other point or points. This entire thing has to be put into a framework. If it
Yes.
is not in a framework, one way or the other,
My lord, before I answer these queries, my lord, if your lordships, my lord, want me to answer all these queries, I am prepared for
yes,
that.
yes,
But what I submit that we are very close to the vacation.
correct.
Now, my lord, your lordship has seen paragraph 48 of the judgment, which says that within 2 weeks, my lord, the new person is to be appointed. And 2 weeks, my lord, expires day after tomorrow.
Who's? The present directors.
No, 2 weeks from the date of the order.
Now, who is continuing to hold the post?
My lord, the present director is respondent number 5. He was selected and he was appointed in July 22. And my lord, in view of this judgment, my lord,
He goes.
he goes and his position has to be taken over by somebody who is to be appointed by day after tomorrow. Therefore, in view of this, my lord, I was only praying that if that situation takes place, the entire appeal will become infructuous. Unless your lordships feel that the appeal is entirely frivolous, then, my
No,
lord,
but then-
stay is a normal consequence.
Followed. Let us please explain the appeal. Place
Yes.
the appeal a little bit.
Lordship. My lord, under the Ministry of Culture, Government of India,
Just the rules will do.
there are 4 zonal cultural centers. Eastern Zonal Cultural Center is one of them, which takes care of 8 states and 1 union territory. It is stationed in West Bengal, in Calcutta. Now, the post of director, there is a recruitment rule in respect of this organization, which applies to all appointments, but it says that the rule shall not apply to contractual appointments or appointments on deputation. Now, here it is a case that director, as per the advertisement, the appointment of director was on the basis of this, either contractual or on deputation. 2 types of candidates could apply. Now, the person who was selected finally, respondent 5 year, he had applied for the contractual basis. There were some others who came on deputation also. Now, therefore, the rule will not apply. Then what is to be followed? Is there a total blank area? No. The Government of India, my lord, has laid down the procedure. The procedure is, this is a practice. The Government of India informed EZCC that we constitute this screening committee. The screening committee will screen the applications on the basis of their eligibility and shortlist this. And thereafter, scrutiny committee.
Scrutiny. Let us
Scrutiny
use the appropriate expressions.
Yes, scrutiny committee. That's the first committee. My lord, that is page 89. If your lordships kindly take page 89. Sorry, page 67. Page 67. May 2022. Page 67, Annexure P2. Subject is, my lord, this is Government of India, Ministry of Culture is writing to the Additional Chief Secretary to the Governor of West Bengal, Raj Bhavan. Subject is filling up of the post of Director EZCC Kolkata, Constitution of Scrutiny Committee regarding. Sir, I am directed to refer to Governor's Secretariat letter number so and so on the above mentioned subject, and to say that as per decision of this ministry, the following 4-member scrutiny committee has been constituted for scrutiny of the applications received by the office of the Honorable Governor of West Bengal, come chairperson of EZCC, against the advertisement published for filling up 1 post of Director EZCC Kolkata. 1 Director, 2 Governor of West Bengal, 3 Under Secretary ZCC, Ministry of Culture, then 4 Under Secretary IFD, Ministry of Culture. Then 2 Scrutiny Committee will examine the applications and will shortlist the eligible applicants. Thereafter, further process for filling up the post of Director Kolkata will be initiated accordingly. Therefore, this is the job of the scrutiny committee. Now, my lord, if your lordship kindly turns over, next page, page 68, what the scrutiny committee does is, my lord, it says, my lord, paragraph scrutiny committee meeting, paragraph 3, a total of 41 applications in original, along with all enclosures were received, etc., from the Honorable Governor Secretariat. Then eligibility criteria are mentioned, my lord, deputation, regarding deputation and for short term, the eligibility criteria are different. Eligibility criteria for deputation is 1, 2, 3, and short term separate 3. These are mentioned here. Then the committee noted that out of 41 applications, 4 applications have applied on deputation, while the remaining 37 applications have applied for on short term contract. The suitability of these applicants were accordingly evaluated on the basis of eligibility criteria provided in the recruitment rules as mentioned in the eligibility criteria above. The committee found only 11 applicants suitable for appearing in the interview before the search cum selection committee. Without pausing here for a moment, my submission is that it is the next committee is not merely a selection committee, it's a search cum selection committee. Your lordships are aware, my lord, a search committee's function is to find out who are the persons who should be called for interview, who should be considered for appointment. But here, my lord, as I find from paragraph 5, the committee found 11 applicants suitable for appearing. Scrutiny committee itself decides that only 11 are suitable for to be interviewed. As if, my lord, the search cum selection committee is merely an interview board. Out of these 11 applications, 10 have applied on short-term contract, 1 has applied on deputation. The particulars of these candidates are given in Annexure 2. Out of 41 applications, 30 applications were rejected by the scrutiny committee for the reasons inter alia given as under. Then, the applications not duly received through proper channel in case of regular government employees. 2, crossing the maximum age limit prescribed in recruitment rules. 3, not satisfying the criteria of eminence in the field of art and culture. 4, not possessing the requisite experience in the field of art and culture as provided in the recruitment rules. 5, not possessing the requisite administrative experience as provided in the recruitment rules. And 6, do not satisfy the criteria of pay scale as mentioned in the recruitment rules. The pay scale may not is applicable to other category. I am not concerned with that. In any event, my lord, if you before this, my lord, kindly come to page 62 again here.
Page
Page 62.
62.
62. We are going back a little. I will take your lordship to paragraph 6, I mean clause 6 of this eligibility criteria. Age limit, etc. It's definitely a subject, my lord, for the scrutiny committee to decide. Then the 6 is eligibility criteria. Kindly omit this for deputation. I am not concerned with deputation. Now, short-term contract. Eminent cultural personalities, practicing artists, scholars or experts in the field of culture with at least 10 years standing experience, possessing bachelor degree, then minimum 3 years administrative experience in running cultural institutions. Now, my lord, I pause here for a moment. Now, eminent cultural personalities.
You're reading from page?
Page 63 bottom, short-term contract, eminent cultural personalities. Who is to decide this? Who is eminent cultural personality? In the field of culture, what is the field of culture? That is required to be gone into. Then possessing bachelor, all right. Then III, next page, page 64 top. Minimum 3 years administrative experience in running cultural institutions. What is the nature of an administrative experience? What is a cultural institution? These are all aspects which need to be gone into in details on the basis of all the documents submitted by the respective parties, not by the scrutiny committee. Then what is the function of the search cum selection committee? Then duties and responsibilities, the functions, I'm not traveling in lordship with this. Now, my lord, I go back to page where I was. I go back, my lord, to page 71. Page 71, my lord, is a list of 11 candidates who the scrutiny committee says are only eligible to be interviewed. Page 71.
Reasons,
Reasons, my lord, no, reasons for their inclusion is not there. But reasons, page, kindly come to page 73, that contains everything. Reasons in regard to all. Page 73 onwards. Number 1,
70.
page 73.
Where is the shortlisting?
No, this gives the reasons, my lord, the remarks in the last column. Remarks last-
71 are the names of 11
No, my lord,
candidates.
73 I'm talking about. I'm talking 73.
73, yes.
71 is the only list only. 73, my lord, gives the reasons on the right hand side, last column. My lord, number 1 fulfills all requisite qualification. Therefore, it says yes. Then next, does not possess minimum 1 year's administrative experience in running cultural institutions. Now, what is a cultural institution? What is an administrative experience? Everything is being decided by the scrutiny committee. Then we have number 3, does not possess. Now, number 3 here, does not possess experience of working in organizations related to art and culture. Therefore, the scrutiny committee will decide what is an organization of art and culture. Then
Very
next,
good. We follow this remarks. Then
then we are, this is the basis of rejection of 30. Now, after this exercise was undertaken by the scrutiny committee, the
Yes.
matter goes over to the search cum selection committee as per page 62, my lord, which says by which the scrutiny committee was appointed. It says in paragraph 2 that the next step will be taken by further process will follow. That process is to be followed further by the search cum selection committee. Now, page 83. By page 83, 20 more are added.
and these are sent to the
These are sent, my lord, to the ministry.
search cum selection committee or to the scrutiny committee. These
No.
20 names.
This is 20 names, my lord, is listed by the search cum selection committee. Kindly see, with reference to your email, I am directed to send the list of 20 candidates other than 11 shortlisted candidates by the search committee. The bracket should end by the search committee, who were called for interview on this for selection to the post of director EZC Kolkata. Name of the candidates as follows. 20 additional persons, apart from these 11, were called for interview at the instance of the search cum selection committee. Now, if your lordship kindly takes the next page.
Where is the advertisement? Could you take us to the advertisement?
Page 62.
The procedure?
Advertisement, then the scrutiny committee, then the search committee.
Page 62.
62 is the advertisement. It continues to page 63 and 64 also.
Then how does the advertisement to be, how is the processing to be done in terms of, where is it laid down, the recruitment rules?
The laid down recruitment rule, my lord, is page 173. It doesn't, my lord, lay down this 173.
173.
Lordship.
Yes, the relevant portion.
My lord, I'll first place, my lord, paragraph, rule 1.2 on the first page, at page 174. Rule 1.2 and 1.2.1.
No, but the method of selection,
Method of selection is not provided here. Full-time employment, yes, page 178.
but how does the scrutiny committee and such, who
This is
constituted
not
that?
since
Under
the rule
what
does
rules?
no, not this is not under any rule. When there is the rule is not applicable, some procedure is to be followed.
So who formulated the procedure? Where
Under
did
the culture, the Ministry of Culture, under that ministry, these committees are set up.
So where are
That was-
those rules codified before
No,
us?
these are not codified rules. Codified rule is 1 to the 2015. And it says it will not apply to deputation or contractual appointment. Therefore, my lord, some mode has to be followed, which has to be framed by the
No, we are only not on contractual or deputation. It may be from any of the sources. That is that is not quite material. It is the relevant roles of the scrutiny committee and the search cum selection. Is there any codification of the relevant conduct? Or who does what first, who does what when, who does what after whom?
my lord, this is a comprehensive rule from all categories.
7.1.
Anyway, please continue then. Otherwise, then we have to go by the definition of a scrutiny
So
committee.
if
a
you kindly
definition of-
takes page 187. 187.
Yes,
7.1. The suitability of candidates for selection to a post shall be considered by a selection committee in an objective and impartial manner. While the suitability of the candidate for promotion, etc., that's the difference. Therefore, suitability of a candidate for selection, that authority rests in a selection committee, not in the scrutiny committee. Suitability. And
Yes.
my lord, when I placed my lord the minutes of the meeting of the scrutiny committee, your lordship has noticed that they say that we have judged the suitability. My lord, kindly come to page 68 for a moment, my lord. Page 68.
yes,
This is the minutes of the proceedings of the scrutiny committee.
yes.
And in paragraph 5, it says that the committee found only 11 applicants suitable for appearing in the interview before the search cum selection committee. The suitability is being judged by the scrutiny committee. We are rendering the search cum selection committee a mere interview board.
Very good. Now we are page 83.
We are at page 83. Yes, page 83 shows, my lord, that 20 more candidates, apart from the 11 shortlisted by the search committee, were also called for interview. Now, the proceedings of the proceeding is at page 84.
What is the role of the chairman? Is it been given in the recruitment procedure? What does the chairman or any of the
So, my lord,
constitution?
what happened here is not, my lord, the chairman individually took any decision. The chairman raised the point, then there was a trail. A trail mail where, my lord, there were discussions took place and the decision was finally taken in the name of the governor, in the name of the chairman, that 20% be also added. And as a matter of fact, I'll place that document also.
Yes,
My lord, the joint secretary to the Ministry of Culture, who was one of the members of the scrutiny committee, he was asked by the Ministry of Culture, scrutiny committee. He was asked by the ministry to call for from the governor's office these additional 20 names, how these are included. That those were sent to the joint secretary and the joint secretary forwarded it to the government of India, and government of India, my lord, produced everything, all these documents, granted its approval to
let us see. From page 84 onwards.
page 84. My lord, first, my lord, paragraph consequent upon conclusion of 3-year short-term period of Gauri Basu director, extension was accorded for a period of 1 year, etc. Then 2, the process for selection of director was initiated by the advertisement notification such and such. Paragraph 3, 4 applications were received beyond time. 4, the scrutiny committee of the following was constituted with respect to 41 applications received within time. Then paragraph 5, scrutiny committee rendered a report finding 11 applications eligible for consideration. 6, Governor of West Bengal in his capacity as chairman EZCC, after taking note of the situation, indicated the 31 applicants, including the 11 shortlisted by the scrutiny committee, be called for interview, taking note of the prescriptions in the eligibility criteria. Then next page, page 85, the search cum selection committee comprised of the following. Then 6 names are six persons are there. Then paragraph 8, all the members participated. Then 9, all the distinguished members exhibited focused approach and effective participation during the entire virtual interview process. In the beginning,
Yes. Follow the lie. Then next, what happened?
then Milord, I just need to place one more line from here. Milord, kindly come to paragraph 10. After the virtual interview process was over, all members except one indicated following 3 names in that order of preference for consideration for appointment to the post of director EZCC. Then 1 is Ashish Kumar Giri, who was finally appointed. Then number 2, Laipubam. 3rd is Atul Trivedi. Now kindly turn over. The 5th member, he had put a note of dissent, and he recommended a different panel. Now, making recommendation in favor of the following 3 in alphabetical order. 1, 2, 3 in alphabetical order. Not saying that in order of preference. And then the committee says that the view of the majority is accepted, and view of the majority is accepted. Therefore, the first panel is sent for consideration. Then page 88. Page 88 is coming from the Governor of West Bengal's office. The recommendation of the search committee, etc. The search cum selection committee, constituted by the Ministry of Culture, Government of India, in order to prepare a panel of persons for making appointments to the post of director EZCC, recommends the following names in order of preference for consideration for the above mentioned appointment: Ashish Giri, Laipubam, and then Atul Dwivedi. The minutes of proceedings held in this regard are also enclosed here too. Then page 89, the next page. It is coming from the Government of India, Ministry of Culture. I am directed to refer to the Honorable Governor of West Bengal, D.O. such and such, on the above mentioned subject, and to convey the approval of the Government of India to the appointment of Mr. Ashish Kumar Giri to the post of director for short-term basis for a period of 3 years or until further, etc. Then paragraph 2, you are requested to apprise Honorable Governor of West Bengal, Chairperson EZCC Kolkata, about the appointment of Mr. Ashish Kumar Giri as director EZCC, and take further necessary action for issuing formal appointment order under intimation to this ministry. Then comes the order of appointment, is at page 90. Page 90 is the order of appointment. It refers to the recruitment rule. This, I say, should not have been done. When the rule doesn't appear, why it has been referred to? Because the rules require that approval of the ministry is to be obtained. Now here the approval was in fact obtained, and that was necessary, in view of the fact that this entire organization is under the Ministry of Culture. Therefore, any appointment to the topmost post obviously requires approval of the central government. That is how it was done. Now,
Yes.
if your lordship kindly take page 167, page 171. Page 171. Request for names of additional candidates. Page 171. Request for names of additional candidates other than 11 names called for interview for selection to the post of Director EZCC Kolkata. This is coming from Rajneesh Mohan Singh. Rajneesh Mohan Singh was the joint secretary.
Please, sorry to interrupt you. Please show us the chairman's role is preeminent, understandable in any situation. Show us from the composition of the EZCC, the overall composition all over India. What is the role of the chairman, role of other directors? Where is the chairman's role defined? What is the chairman expected to do, supposed to do, his level of discretion, exercise of discretion? There must be some
That is,
rule.
of course, that is not in the recruitment rules. There must be some regarding its constitution rules.
There must be a Government of India, Ministry of Culture. Where do we get what are the functions of the chairman? What is the
Rules for
level
the-
of his
for-
discretion?
rules for the constitution of the committee.
That's
There
right.
must be some rules, but that is not here on record. That is not here.
Apart from the specific recruitment rules, we need to see
I have followed,
what is the area of operation of a chairman.
I will submit. I don't have that, to be very candid before your lordship. I don't have it now. And that was not, a thing, taken into consideration by the learned single bench. Now, in any event, I submit is that it was in any event not an individual decision of the governor at any stage. It was pointed out by the governor, of course. And then, these 20 additional names that is also being sent, we asked for by the central government.
There are two, sorry to again interrupt you. Even assuming the chairman could do that, exercise discretion, the 20 additional names ought to have been routed then through the scrutiny committee, not directly to the search cum selection committee, number one. Number two, there was a last date for receiving within 45 days. These names were sent directly to the search cum whatever committee, selection committee, the second committee, directly from the office of the chairman upon consultation. It was not filtered through the scrutiny.
It was filtered.
Where is the
Lord,
opinion of the
I
scrutiny
put your
committee
lordship-
filtering these additional
74
20 names?
onwards, the scrutiny committee, in respect of all the 41 candidates, gives his reason. He is not.
Sorry to again interrupt you. There were reasons for rejecting the 41
for
candidates.
rejecting and accepting.
Correct.
Out
Correct.
Of 11
What about these 20 candidates? Reasons for rejecting or accepting these 20 by the scrutiny committee? Where is that process?
All from page 74 onwards. Page 74 onwards contains all 41, including this 20. 20 is not coming from the sky. These 20 were the applicants. And their cases were, their records were also put before the scrutiny committee.
Where do we get that?
I cannot give all the names of these 41 persons.
So these
But if your lordship kindly takes one. We have by now, got some of the names. Now, for instance, the person who was appointed.
Page 73.
Page 76, if your lordship kindly takes page 76. He was one of the additional 20 candidates. His name is page 76. Page 76 under serial number 18. Now, what is the reason for finding him not suitable? Does not possess minimum 3 years administrative experience in running cultural organizations. But the documents show me, that he was in the All India Radio as a project officer for several years. Several years.
So where is that? Where is the reasoning? Where is that this has been the search cancellation committee can override the decision of the scrutiny committee if we take it. Then there has to be a reasoning reflected. That serial number 18, incorrect reasoning given by the scrutiny committee.
Entire documents regarding experience had been submitted by all the 41 candidates. And the entire records were available both with the scrutiny committee as well as the search council.
So these 20 were part of the original 41.
Of course, yes.
Then why do we call them additional?
Additional means 11. Scrutiny committee says only 11 will be interviewed, none else. 30 rejected. Now these 20 are out of these 30.
Out of the 11, but within the 41.
Yes. Exactly, exactly.
Out of the 11, but within the 41.
Within
So
41.
therefore, the question of being additional does
No,
not arise.
additional term is not proper.
That is number one. Number two is then the governor uses his discretion to bring in those 20 back again into the
Yes.
overriding the scrutiny by the
Sir,
scrutiny committee.
I will submit, my lord, that possibly the governor did not, in his individual capacity, do that.
No, nobody is saying that. Nobody is saying that. Even may not have been done it. But the procedure, if you bring back those 20, if a rejection, then you have to give reasons why scrutiny committee was wrong and why it is to be overruled. You just cannot mechanically bring in those 20 for the interview.
No, certainly it cannot be done mechanically. But if I find, my lord, that this rejection is apparently on the face of it wrong, I find, my lord, he has 30 years experience. And it says that he doesn't have 3 years experience. In this case, my lord, it is something like that. It is so apparent on the face of it, my lord. At least in regard to serial number 18, I can say that he had been holding the post of project officer in All India Radio for more than 10 years. And it says he doesn't have 3 years experience, 3 years administrative experience in a cultural organization.
So how is the single bench dealt with this?
Single bench says that All India Radio is a cultural organization. Nobody has come forward to say that. All India Radio did not come forward to say that. And All India Radio was made a part.
Well, that is a tidbit. Well, what is the major finding of the single bench on this
Your
subject?
major finding is that, Lord,
Which paragraph? Where does the single bench discusses this conflict between scrutiny and committee and the search consolation? Minor bit whether All India Radio is that's a
kindly come to internal page 35.
35, paragraph UU. 35, paragraph U.
Lordship, yes. I'm grateful to my friend. Paragraph UU, my lord, at the bottom of page 35.
yes,
Internal page
you,
35, which is at page 269, serial page.
correct.
UU, the issue of the present case is that whether or not a candidate can be considered to be eligible in the present selection process, once the scrutiny committee held the person to be ineligible. Whether the issue of eligibility could be considered overriding the decision of the scrutiny committee by the Honorable Governor or the search selection committee. This court finds that the recommendation of the scrutiny committee has been rendered OSHO by another authority acting beyond its jurisdiction.
This is the issue.
This is, my lord, the court finds that the search selection committee acted beyond its jurisdiction.
This is the summary of the finding.
Let us continue. Let us continue.
Admittedly, respondent 5 used to work as a program executive with the AIR in pay band 2, pay scale so and so, in grade pay so and so. Therefore, the private respondent 5 was not eligible to apply on deputation, even though he was in regular service or holder of a post on regular basis. I did not apply. He did not apply on deputation basis at all. The pay scale is a factor relevant to a deputation applicant. Candidate who could apply on deputation basis needed to hold a post, etc., for such and such. For required 3 years regular service in pay scale number. Therefore, the court has gone wrong. This, my lord, if your lordship kindly takes my lord page 63 for a moment, my lord, on this aspect.
Page
63. Advertisement. Page 63, now serial number 6.
63.
63. 63.
Of the state.
Eligibility criteria, serial number 6, at page 63. There is a chart, my lord, at page 63. Is part of the advertisement itself.
No, we are not, to be at this stage, we are not on his suitability or lack of, he may have applied on a short-term contractual basis because he did not meet.
No, but the learned judge says, my lord, that he didn't fulfill this. He was not required to fulfill it.
But is there a contingency clause that this rule may be relaxed in certain cases? There are clauses which are savings clauses. Are there any savings clauses in
No,
this?
Milord, here the rule proceeds, the recruitment rule proceeds on the basis, Milord, that this rule shall be applicable to all regular permanent appointments. And it excludes, Milord, appointment made on deputation or contractual basis or ad hoc basis. These are excluded from the operation of this rule.
Very well.
Therefore, Milord, the government of India, Milord, follows this practice. First, a scrutiny committee, the candidates shall be, the applications shall be processed through, then to be followed up by the search conciliation committee. Thereafter, it goes over to the government of India in the ministry to consider, Milord, whether the steps taken is right or not. If yes, government grants approval. If not, the appointment, this proposal is disapproved. That is how, Milord, the things proceed. And here, that exactly is if you are, as EZCC, we are bound to follow whatever the government directs us to do, and that is what we have done. And the government finally have accepted everything. After, Milord, government asked for this, why these 20 names more? Why beyond 11? Government asks for it. We send it. Why? The reason why this entire records are sent again with regard to these 20. Government produces all these things, accepts, grants its approval, and directs that appointment letter be issued by the government. That is the situation. And on the basis of that, Milord, he was appointed in July 2022. Now, one other factor. Milord, the grievance has been raised in the writ petition that why these 20 persons have been interviewed.
Why?
These 20 persons have been interviewed over and above 11. Now, in the writ petition in paragraph 12, there is a specific pleading that on the date of the interview, the candidate who was the writ petitioner, the candidate came to know that 31 persons are being interviewed. He knew it. He participated in the interview process.
That is that standard argument. He participated and therefore he.
Standard argument, but just an additional fact.
Yes.
He did not take any steps thereafter. It is only after the result is issued, the person is appointed, he makes an RTI application about these 20, how this is done, etc. And thereafter, the writ petition is moved. Therefore, Milord, he took this calculated chance, Milord, that aspect.
There are some contrary judgments also to that.
Provided, Milord, those contrary judgments are in situations where
Correct.
you challenge the rule. The rule is wrong. Therefore, Milord, it cannot be said that I have waived an illegality. In those situations, the contrary judgments are there. But not, Milord, in a situation where the entire directive of the government is followed.
So the gentleman appointed in July 2022 is continuing. His appointment has been now set aside.
Yes.
And one of the members of the panel who was part of the scrutiny committee's recommendation has been now directed to take charge.
No. The minority panel.
That's right.
Minority panel, the court says you follow the minority panel, appoint one of the three. Because a minority panel said, does not say in order of preference.
Then what is the reason for appointing from the minority panel?
The reason is because minority panel all are from the 11.
And about the majority panel, they are from
both.
11 plus 20.
Yes.
Where is that part? In the single benches order?
In the single.
Before we move over to the Solicitor General.
Lordship. There are page 272 running page, internal page 38 of the judgment. Paragraph 48.
Yes.
Paragraph 48. In the light of discussion made herein above, WPA so-and-so is allowed by quashing the subsequent list of 20 candidates. Letter of recommendation dated 26 May 2022 and the letter of appointment of the private respondent dated 5th July 2022, but not the government approval. Kindly note this. Accordingly, this court directs the suitable candidate from the panel recommended by the Joint Secretary ZCC to be considered. This is the Milord solitary dissent. Solitary dissent came from this Joint Secretary ZCC to be considered for appointment to the post of Director ZCC by the Executive Board in consonance. Now the judgment says by the Executive Board. Now, executive board has to appoint when the rules apply, the recruitment rules apply. Kindly see the confusion. The rule says that in the case of appointment of a director, it has to be with the approval of the central government, and appointment should be made by the executive board. The learned court says that the executive board should appoint this. Executive board, my lord, is not a person, my lord, who he is the person, my lord, named in the recruitment rule, which rule doesn't apply. In consonance with the approval of the government of India within a period of 2 weeks from date, the 4th of May, the judgment was delivered. And 2 weeks, my lord, takes us to day after tomorrow. Therefore, by day after tomorrow, the appointment is to be made. And once the appointment is made, the appeal will become infructuous.
Yes, we come back to you after we hear some of the other parties. Yes, Mr. Solicitor General.
My lord, if your lordships feel that the matter is to be gone into in all the details, then the appeal is, the matter is to be heard as an appeal. I was praying for this, my lord, before the vacation. Your lordship possibly will, it will not be possible for your lordship, my lord, to hear the appeal itself.
Let us see to what extent we can go today. We are true. It is before the vacation, very few days left. But let us see to what extent we can travel to touch. Yes, Mr. Solicitor.
Not only-
May I take a short leave from your lordship?
Yes,
Not the only thing I can
you
submit.
can
before your
raise the
lordship
microphone
today.
to you.
The only thing I can submit before your lordship today is, on behalf of Government of India, is the entire process.
On
has been
behalf of Government of
Entire
India.
process has been approved by the Ministry of Culture, Government of India. My lord, I don't find anything malafide pleaded in the writ petition, except that the scrutiny committee had no, the search and selection committee had no jurisdiction to include the names. Now, nowhere I find that the scrutiny committee has been given unfettered power to reject the applications, and that shall be final. The finality shall be this, number one.
Just a minute. Please ask your learned juniors. There are 3 appeals. There will be a common order. So please give the nature of representation in each of the appeals.
Yes,
Otherwise, we shall just routinely reproduce the names. So
Yes.
it will hurt your ultimate
yes.
purpose.
Yes.
Yes.
My lord,
Yeah. Go.
the issue. Now, the question, my lord, is that whether the search and selection committee can override the decision of the scrutiny committee. Because nowhere it has been placed before your lordship by Mr. Gupta that the decision of the scrutiny committee is final. Therefore, the learned judge erred in law in deciding that issue, that the search and selection committee had no jurisdiction to enter into such question and include the names.
Yes.
Now, on the only one score, your lordship will kindly grant stay of the order appealed against. Kindly come. That has been read out by Mr. Gupta to the impugned order, the last part. Where from the learned judge got this, that my lord, the decision taken by the joint secretary in a minority view, that has to be implemented. That is neither here nor there.
Page.
My lord, page 40, paragraph 48 of the internal page 38 of the judgment. And running page is 141 in my brief.
Paragraph 48.
48. That has been read out by Mr. Gupta in detail. My lord, only kindly see, accordingly, this court directs the suitable candidate from the panel recommended by the Joint Secretary JCC, not the panel of the Ministry of Culture, Government of India. From the JCC is a minority view. How can the learned judge direct this? That has to be done, and appointment has to be made on the basis of the minority views recommendation.
Where are the competing recommendations? In which page are the recommendations? Majority, minority must be given. We noticed somewhere in the stay application, the pages are there. The recommendations.
67 na koto page আছে?
Well, that is.
I think when Mr. Gupta was arguing, we could just have a glimpse at those pages. Yes, page 88. Where is the minority recommend? Page,
No, yes,
$85.
kindly come to page 84 of my brief.
yes,
That has been read out in detail by Mr. Gupta.
yes.
If you're lost, you kindly stands over to page 85. That para 7, the search cum selection committee. The search and selection committee comprised of the following. What was the necessity of constituting a search and selection committee? By the chairman, joint secretary, Dr. Swarup Prasad Ghosh, Dr. Sachinanda Joshi, cultural secretary, government of Jharkhand, cultural secretary, government of Manipur. Therefore, the joint secretary of the JCC Ministry of Culture, who is a member, only a member, and that his recommendation has not to be followed for the recruitment process. Fifth member. My lord, no, no. Now, if
all members except one. এটা আমাদের ব্রিফে 84
is
আগেরটা স্যার
Yes.
now,
Now-
Lordship, if your lordship kindly comes to page 86, the minority view, the only one member out of the committee,
5 member
out of the 5 members, the fifth member, joint secretary, JCC, MOC submitted a separate input, making recommendation in favor of the following 3 in alphabetical order. This is neither here nor there, not in terms of the rules. Where from he got the jurisdiction to recommend? There was a consensus view of the search and selection committee. Secondly, my lord, if your lordship kindly comes to page
So this
my
was
brief,
at page 86, paragraph 11 was directed to be implemented by the single bench.
yes. The joint secretary's recommendation
Was directed to
in a
be
minority view,
implemented
that
by the
has to be
honorable
recommended.
single bench.
That has to be stayed. This is neither here nor there. Where from the learned judge got this, that it has to be implemented and appointment has to be made from this panel.
Any of these 3 names were part of the 20 names, additional 20 names?
No, they are part of the 11 names initially shortlisted by this scrutiny committee.
At paragraph 11.
Yes. Now,
All the
lordship
3
kindly
names-
comes once, my lord, to the,
Please come to page 86, paragraph 11. The 3 names belong to the additional 20 and the original 11, or only the original 11, or only the additional 20.
the original 11. The
Original.
original 11.
So the view of the honorable single bench was not the minority view be respected, because the original 11, they are part of the
Yes,
original
yes,
11.
yes.
Therefore, because of the procedure, follow that procedure.
Yes. My lord,
Logic is-
the joint secretary participated in the selection, search cum selection proceedings meetings. The minutes were recorded.
So the honorable single bench never emphasized this view because of a minority view. Because
Exactly.
this is part of the original 11, therefore follow it.
Yes, yes, yes. Now, my lord, only one more thing I have, Mr. Kaur, is to apprise you lordship about the respondent number 5. The kindly come once in the list to, my lord, the detailed minutes recorded by the chairman's office. That is at page 98 of my brief, and my lord, possibly these are the minutes in detail recorded by the chairman's office, the honorable chairman's office, list of documents which are considered for arriving at a decision. So, my lord, if the decision has been taken rightly argued by Mr. Gupta that this is a contextual appointment. And for that contextual appointment, this is not to be argued before your lordship. This strict rigor of the rules and the other rules framed under Article 16(1) or under 309 shall prevail. Because it's a question of procedural propriety to appoint a person that has been read out in terms of, with regard to the short-term contracts. There are two distinctions about the short-term contract and the regular appointment. About the regular appointment, the rules will apply and the rules have a force, definitely. But in case of a contractual appointment, this is the policy decision of the government of India to appoint a person and to implement the policy of the cultural department. Number one. Finally, my lord, if in the entire recruitment process, the writ petitioner who participated even after the inclusion of the other names before the search and selection committee, he participated in the proceeding, and having been unsuccessful, he has come before the writ court, and there is no allegation of malafide taken in the entire recruitment process, except that the scrutiny committee had decided it excluded, and the search and selection committee had no jurisdiction to include these names. So therefore, my lord, what Mr. Kaur will submit in support of his client's candidature, these are at present the submissions on behalf of the Ministry of Culture.
Yes. Yes, Mr. Kaur.
May I please, your lordship? Lord, if your lordships kindly take the judgment first. Lord, I was working as a regular employee in All India Radio. Now, my lord, when I applied, I gave a declaration that I am a regular employee, but I am prepared to join on short-term basis. I will take a voluntary retirement. Now, my lord, pursuant to the appointment, Lord, I had taken the voluntary retirement, and Lord, I joined. So, my lord, I am in a double jeopardy. I've lost my job because of this appointment, and now, my lord, I am at a peril because of the order of the impugned order of the learned single judge. But Lord, before I take your lordship to the merit, if your lordships kindly, my lord, take paragraph UU of the judgment, page 35. Internal page 35 of the judgment, paragraph UU. The issue of the present case is that whether or not a candidate can be considered to be eligible in the present selection process once the scrutiny committee held the person to be ineligible. Whether the issue of eligibility could be considered overriding the decision of scrutiny committee by the Honorable Governor or the such selection committee, this court finds that the recommendation of scrutiny committee has been rendered odious by another authority acting beyond its jurisdiction. Now, Lord, I first restrict my argument, legal argument on this. Lord, let us assume the rule of appointment applies. I am not, Lord, giving up any points, but Lord, let us say for the sake of argument, rule of appointment applies. Now, Lord, your lordships have seen clause para 7.1 of the rule, which clearly says that this selection committee is the appointing authority. Suitability of the candidate will be looked into by the selection committee.
Let's see that.
Yes, your lordships may kindly have a look at 63 na koto ekta pataয় bolchilen. Eta please bolun ekটু. Please come to 174, I think. 187. 187. Please come to Lord, page 187. Kindly have a look at clause 7.1.
Yes.
Chapter 7, it says selection and departmental promotion committee. Has your lordship found that? It says the suitability of candidate for selection to a post shall be considered by the selection committee in an objective, impartial manner. While the suitability of promotion, we are not concerned with the promotion. Let us say, Lord, the rule applies. Then the authority to find out who's suitable is not to be found out by the selection committee. Now, my lord, what has been done here is that a part of the duty of the selection committee has been delegated to a committee which is called the search committee.
Scrutiny. Committee.
Sorry, scrutiny committee, not search committee. I stand corrected. Scrutiny committee. Now, my lord, this is a power which is delegated from the selection committee to the scrutiny committee. Now, my lord, as a result of this delegation, does the selection committee lose power to oversee the recommendation by the scrutiny committee? This is the basic issue, because, my lord, foundation of the impugned judgment is based on this. Paragraph UU, the learned judge has held that by reason of the two committees, one being carved out of the other one, they have lost all the powers. Now, my lord, this is a point of law which is well settled, because, my lord, the principal who has delegated his authority to another person as his agent to carry out some work does not mean that he loses his power.
Just a quick question in the meantime.
Yes.
We were with Mr. Gupta on this question. So these 20 are part of the original 41.
41.
So their applications were there,
Yes.
but 11 were only included, 20 were out because of the scrutiny committee.
Scrutiny committee.
So these 20 were not imported from outside.
No.
Anywhere. These 20 were returned by the chairman.
Yes. Lord, what had happened, I tell your lordship. Total 40 or 41 applicants had applied.
41.
Now, my lord, these applications were given to the screening committee. Now, scrutiny committee. I again stand corrected.
Because here nomenclature is very important.
Very important, very important, very important. So, Lord, 41 applications given to the scrutiny committee. The scrutiny committee filed a report approving 11 candidatures, rejecting the rest, 30. And they gave their reasons for rejection. The reason for my rejection was I did not possess 3 years administrative experience.
Whatever be that.
That is the ground. Now, my lord, the matter goes back to the selection committee.
Search comes selection.
Search comes selection committee. Now, Lord, when the matter goes back, whether the search comes selection committee have the power to look into the scrutiny, not only restricted to 11, but also with regard to rejection of 30. This is not what I am trying to argue before your lordships as a legal issue.
Got the point.
Legal issue. Now, my lord, kindly consider one judgment on this. This is, my lord, reported in 1974, volume 4 SCC, page 98. Lord, the judgment, Lord, starts at page 98. Lord, please come to paragraph 37 and 38 first. Paragraph 37, Lord, I read first. This is at page 116. In this context, it is necessary to have a clear idea of the concept of delegation. Has your lordship got that?
Yes.
Delegation is not the complete handing over or transference of a power from one person or body of persons to another. Delegation may be defined as entrusting by a person or body of person of the exercise of a power residing in that person or body of persons to another person or body of persons with complete power of revocation or amendment remaining in the grantor or delegator. It is important to grasp the implications of this, for much confusion of thought has unfortunately resulted from assuming that delegation involves or may involve the complete abdication or abrogation of a power. This is precluded by the definition. Delegation often involves the granting of discretionary authority to another, but such authority is purely derivative. The ultimate power always remains in the delegator and is never renounced. Then, Lord, there is a quotation from Hutt versus Clark. It says, delegation as the word is generally used does not imply a parting with powers by the person who grants the delegation, but points rather to the conferring of an authority to do things which otherwise that person would have to do himself. It is never used by legal writers, so far as I am aware, as implying that the delegation person parts with his power in such a manner as to denude himself of his rights.
So you would mean to say that this scrutiny would have been as well done by the search cum selection committee.
Correct.
But it parted with this scrutiny
Yes,
to another committee.
absolutely.
And that
of India, that did not, Lord, a rule did not prescribe for that. But Lord, it was basically, Lord, taking the power of the selection committee. This power was given to the scrutiny committee.
so you mean to say that it was a process of selection throughout?
Absolutely.
So if it was a
Absolutely.
process of selection throughout, even at a subsequent stage, the selection committee did not forfeit its powers to select.
Absolutely. And Lord, I go one step further. I say the rejection by this scrutiny committee did not become final. By the time, Lord, the selection committee looked into it.
Let us have a look at the rule once.
Kindly, my Lord, have a look at the rule. Lord, look at 7.1. The rule is very skeptic, but Lord, unfortunately, I tell your Lordship, in course of interaction, if the learned judge had posed this question, Lord, this could have been answered before the learned single judge. But Lord, we proceeded on the basis that, Lord, that there is no conflict between the two committees. They are, Lord, part of the same committee. It
Same
is
selection exercise.
same selection exercise. So, Lord, one scrutinizes and then, Lord, places before the selection committee. Now, Lord, scrutiny.
There is a catch there. Sorry to interrupt you. There's a catch there. The reasons given for refusing the onward movement of a candidate
Correct.
are technical reasons.
Correct.
How does a selection committee override those technical reasons?
Because of
Like
the
3 years, not this, 3 years,
Correct.
not that.
correct. Because of the documents which were there with the application. Lord, if your Lordship kindly takes my application,
7.1 first.
no, 7.
And then we will come to that
Very
portion where you are rejected on a technical reason.
factually, Lord, I will establish beyond doubt, because I had filed an affidavit in the writ petition, disclosing my administrative experience, and Lord, I had cited a judgment which clearly says that if I am within the zone of consideration and I am rejected, that gives me a right. I would have challenged, Lord, the rejection. I would have challenged the rejection.
Let us see 7.1 and
7.1.
go back to that.
Please come to, Lord, page, I'll just give me
187.
180. Function. First, Lord, chapter 7, it says selection and departmental promotion committee. Has your Lordship got that?
Yes.
Then the suitability of candidate for selection to a post. Now, Lord, I pause here for a moment. The suitability includes, Lord, my qualification, my eligibility. This aspect also, which Lord takes care of the word suitability. Suitability would include everything, every aspect of the matter relating to my service. It says suitability of candidate for selection to a post shall be considered by the selection committee in an objective and impartial manner. And then, Lord, I don't read the promotion part.
No.
Then, Lord, please see composition of selection committee. Lord, there is no dispute that the authority has selected. There can't be any dispute. The only dispute is whether the authority could override the decision of this, the
Scrutiny.
scrutiny committee. This is not the object, because that is the reason I read paragraph UU first. That, Lord, the learned judge
That is the
was
point.
of the view that their jurisdictions are separate. They can't overlap. And once you overlap, it is outside your jurisdiction. This is how, Lord, the judgment, Lord, has proceeded. My humble reading of the judge. To that, I react by saying that, Lord, the rules does not provide for a scrutiny committee. This scrutiny committee power was carved out of the selection committee for the purpose of, Lord, constituting the scrutiny committee.
But there is nothing on paper on that.
No, there is nothing on paper. But, Lord, if your lordship sees the appointment of the the scrutiny committee, they had to be appointed. They had to be appointed. It was not automatic. They had to be appointed.
And these search and selection committee were part of the rules.
Part of the rules.
Show us the appointment.
Yes. Lord, appointment, a lordship wants to see the appointment order.
Okay, you can show us the pages, because everything what you speak
Yes.
has to be backed by some.
Yes,
Some written.
Of course,
But
of course.
it cannot be an argument of.
No, of course.
You forgive the expression, an argument of convenience.
No, absolutely not. Absolutely not. Lord, kindly come to আপনার দুঃখিতা তোমার affidavit, ওই যে প্রসিডিংসটা যেটাতে অ্যাপয়েন্টমেন্ট সাজেস্ট করলো, সিলেকশন করলো, ওই পেজটা এখানে 94. Would your lordship kindly take page 94?
Yes.
Here. Would your lordship kindly see, Lord, this is a document which says proceedings regarding the appointment of Director, Eastern Zonal Cultural Center, EZCC.
Yes.
Has your lordship found that?
Yes. RTI application.
No, not RTI. Lord, it says proceedings regarding the appointment of Director, Eastern Zonal Cultural Center, EZCC.
Page. Yes. Yes. Page 84.
Page 84. I'm sorry. Has your lordship got
Let
that?
the junior sit close to you. You sit close to, because the pages will be important.
Actually,
Yes.
he's assisting.
No, that's all right. That's all right.
Oh, sorry.
The-
Thank you.
Yes.
Lord, if your lordship's, Lord,
Page 84.
page 84. It says, consequent upon conclusion of 3 years short-term period of Gauri Basu as director, extension was accorded for a period of 1 year or until further orders, whichever is earlier. The process for selection of director was initiated by advertisement notification that attracted 41 applicants within the time limit of 45 days. 4 applications were received beyond the time limit. The scrutiny committee of the following was constituted with respect to 141 applications received within time. Then the scrutiny committee rendered a report finding 11 applicants eligible for consideration. The Governor of West Bengal, in his capacity as chairman EZCC, after taking note of the situation, indicated that 31 applicants, including the 11 shortlisted by the scrutiny committee, be called for interview, taking note of the prescriptions in the eligibility criteria. The such selection committee comprised of the following. Then, Lord, the Constitution, all the members participated in the virtual interview on 20th May 2022. All the distinguished members exhibited focused approach and effective participation during the entire virtual interview process. In the beginning, all the committee members were urged to indicate 3 names in the order of preference for consideration for appointment to the post of director EZCC, keeping in view the mandate of EZCC. After the virtual interview process was over, all members except one indicated the following 3 names in that order of preference for consideration for appointment to the post of director EZCC. Then please come to the next part. The 5th member, Joint Secretary EZCC, MOC, submitted a separate input enclosed thereto, making recommendation in favor of the following 3 in alphabetical order. In this premises, the following names in that order were recommended by the committee for consideration for being appointed as per director. So, my lord, I go stepwise. None of the committee members had objected to the name inclusion of these 20 names. I have substantiated the reasons in my affidavit to show why my name ought to have been included, because I was excluded on the ground of experience. Now, my lord, my documents which are annexed to the application was not taken into consideration. Therefore, my lord, when the matter went to the selection committee, all the members, they did not object to inclusion of the 20 names. They considered the 31 names. The only dissension between them was that everybody, 4 of them, suggested the first 3 names in this order that is recorded. One member, Lord dissenting, he had suggested 3 names in a different order. Therefore, Lord, the majority view was sent to the central government for the purpose of appointment. Now, Lord, I personally, Lord, and it is my humble submission, don't see any infirmity in the decision-making process. Because as your lordships have laid down repeatedly, the judicial review is not restricted to the decision-making process. And Lord, your lordships will not find a single finding in the judgment with regard to any imperfect procedure being followed. What is the learned judge, Lord, struck the learned judge is that there are 2 committees. They are not part of the same committee. They have independent jurisdiction. This committee have taken a decision. Therefore, the other committee could not have overridden the decision. And therefore, zone of consideration should be restricted to 11 candidates. This is, Lord, the basis of the judgment in my humble reading. And I say that this reading is totally wrong because, Lord, the law says otherwise. If the selection committee is the only body under the rules to have looked into the suitability, then, Lord, apart from selection committee, nobody else can look it. Merely because, Lord, the scrutiny committee has been constituted, it does not take away the power of the selection committee to scrutinize. And if they find that there was something wrong in this decision-making process of the scrutiny committee, they had every authority to correct it. And not every member of the selection committee proceeded on the basis that 31 qualified.
So this joint director MOC who gave he was part of the scrutiny committee.
5. Part of the 5. Part of the 5.
Part of the search and selection committee, but also part of the scrutiny committee. No. And what was your scrutiny? Where did your scrutiny go wrong according to this?
My scrutiny went wrong.
As an illustrative case.
Yes. And I just not concentrate on my case.
Page 76.
Page 76, Lord, it starts.
Rejection.
Rejection, Lord, kindly see serial number 18. The rejection page. Sorry. Page number 76. 76. Please come to 76. Kindly see the rejection.
Mr. Gupta had pointed out to all this.
Yes. In fact, factually, Lord, he had submitted. Therefore, I had not taken your lordship to the fact. Kindly see serial number 18. Ashish Kumar Giri. It says, does not possess minimum 3 years administrative experience in running cultural institution. Now, Lord, All India Radio is a cultural institution. And Lord, kindly see my application that I had filed, which is annexed to, Lord, the main writ petition. Kindly page টা বলবেন? Just application page 100 and application. It is the last annexure to the writ petition. ওইটার পরে আছে, এটার পরে আছে। আমাদের নয়, ওদের অ্যাপিলে দেখছেন জজ সাহেব, আমাদের অ্যাপ্লিকেশনটা দেবো কি করে? এই জন্য বলেছিলাম যে আপনাদের ব্রিফের একটা কপি আমাদের দিন। Please come to page 109. Please come to page 109.
Yes,
Lord, please come to, এটা first page টা কত? Page 109. Please come to page 109. It starts at page 109. Has your lordship got that? Please turn the page, come to page 110.
yes.
Lord, kindly see serial number 9. Administrative experience in case of cultural personalities in running cultural institution. More than 20 years of experience in running national level cultural organization. All India Radio is a cultural organization. And Lord, please see serial number 8, achievement and experience. All the facts are there. Every little details was there. And I say that, Lord, when the rule 7.1 says that suitability has to be judged objectively, the selection committee could not have excluded me. For the purpose of exclusion, if I was excluded even by the selection committee, I would have filed a writ petition and I would have succeeded. And that is the view taken by the Supreme Court. If your lordships kindly, Lord, permits me, there is a judgment 2013 volume 16 SCC. এটা দাও, তোমার কপি আছে, ওনার কপি আছে, কপি আছে।
And apart from that, paragraph 10, you're multi-talented. Writer, singer, playwriter, lyricist, filmmaker, also an administrator.
And Lord, as the my affidavit is there, I can show it from my
It's a
affidavit.
rare combination.
I can show it from my affidavit that, Lord, as program executive, I had a lot of, Lord, administrative job. I had a lot of administrative job. I filed a detailed affidavit. There is no reference to my affidavit in the MPU judge. I didn't want to take your lordships through all this, but not even a word that, Lord, my affidavit, I have explained my experience, my qualification, everything is there. And Lord, in one word, the scrutiny committee says, Lord, I have no experience. 3 years experience, administrative experience is not there.
But you applied for a short-term contract, not
Yes.
on deputation.
I have applied for a short-term contract because, Lord, this is a position. Lord, will give me an opportunity to work. My cultural experience will really give me an opportunity to work. I was looking for this opportunity, so I gave up my job in All India Radio, and Lord, I applied.
So deputation would have been a more logical approach.
True, but Lord, deputation,
You took a voluntary retirement.
I took a voluntary retirement, and Lord, I applied for this contractual job.
Anyway, but that's a personal aspect.
That is absolutely, Lord, a personal aspect. And Lord, in the affidavit, I have tried to explain why I did that. But Lord, today, Lord, we are only on a prima facie case.
Correct, correct.
Because, Lord,
We would be running short of time, so let us, 1 minute, 1 minute. Ashbima?
permits, my lord, just one paragraph. That, Lord, if I come within the zone of consideration, how my selection has to be looked into. Ah, 2013, volume 16, SCC, page 440. Please, my lord, come to paragraph 19. Please come to placitum G. Just above placitum G, the sentence starting with the word, this is because the state government had to do first was to find out as to who fulfilled the criteria.
Yes.
Undoubtedly, a large number of persons will fulfill the criteria, being gazetted officers with more than 8 years of service and less than 54 years of age on the relevant date. Then, Lord, please turn the page, come to placitum B. The sentence starting with the word, however, once a candidate comes into zone of consideration and satisfies all requirements, including that of outstanding merit and ability, he cannot be told that merely because he is junior in the seniority, his name will not be forwarded for consideration. Then last sentence, he cannot be eliminated merely on the ground that he is junior officer and that if selected, he will write the ACRs of his superiors. Then, Lord, paragraph 20, placitum D. If there is a criteria laid down for selection, has your lordship found that?
Yes.
The administration has to confine to the same, and it cannot impose an additional criteria over and above whatever has been laid down. If that is done, it will no longer remain an exercise of discretion, but will result into discrimination. It will no longer, it will mean treating similarly situated employees dissimilarly and denying equal opportunity to some of them in the matter of public employment on the basis of a criteria which is not laid down, resulting into violation of Article 14 and 16(1) of the Constitution.
That will be enough for now. Let us just let the writ petitioner put in a word.
Lord, I only say that, Lord,
All affidavits were exchanged before the single bench.
I filed my affidavit. Lord, I put my case on record. And Lord, I say that I was discharging because no interim order was granted at the initial stage.
No, all affidavits were exchanged. And you let the writ petitioner put in a word.
Lord, may I just add one sentence? The scrutiny committee was constituted with 4 members. And the search cum selection committee was constituted with 6 members.
Yes, Mr. Victor Chatterjee. Mr. Court, that will be enough for the moment. Let us see.
Much of.
The scrutiny committee was constituted by the ministry. It was not constituted by as a part of the selection committee or it has not been delegated by the selection committee. Kindly have a look at the formation of the scrutiny committee as page 67. It says that it has been formed by the ministry. Page 67, my lord. The Undersecretary to the Government of India writes, my lord, I am directed to refer to the Governor's Secretariat letter dated 11th May 2022 on the above mentioned subject and say that as per the decision of the ministry, the following 4 members scrutiny committee be constituted for scrutiny of the applications received. So my lord, it is not that it was a delegation of a part of the functions of the selection committee. It was a conscious decision taken by the ministry to form a scrutiny committee comprising of high-ranking officials of the government. Well, the designation of the members of the scrutiny committee makes it clear that it cannot be a committee to only to technically assess whether the applications are properly filled up or the persons are overaged or not. This is not that kind of a committee. Because the members, my lord, they are high-ranking officials of the government. So, when a decision has been taken by the ministry to form an expert committee to scrutinize the applications received for this recruitment purpose, my lord, I say, my lord, that process, and when that process has been initiated, it cannot be diverted from. It has to be followed as it was going on. My lord, the question which fell before the Honorable Single Judge, it was repeatedly asked by the Honorable Single Judge that how these 20 names, this from the ineligible 30 was produced before the interview board. What was the decision? How these names came? Well, different reasons were given by the respondents. In the report filed by the EZCC, my lord, it says that to widen the scope, this has been done. The private respondent in his affidavit says to give me equal opportunity, this has been done. But there is nothing on writing how this decision was arrived at. But I say when an expert committee has given expressly given reasons for declaring certain candidates as ineligible, then to override that reason, application of mind is required, and that another and the search cum selection committee has to sit over it and give its own reason for calling these candidates by duly considering the reasons of their ineligibility. My lord, 30 candidates were declared ineligible. Out of that 30, when all 30 has not been called, only 20 has been called. Then again, there is a discretion, my lord, of shortlisting these 10 candidates out. So there was some mechanism which was gone through to select this 20 out of the 30. That is also not on record how this was done. My lord, the decision, I say that the delegation part, my lord, this is not a case of delegation because, my lord, there is nothing on record to show that the selection committee by itself has delegated the power. Whereas the selection committee's minutes says that the chairman, if my lord kindly comes, my lord also already has gone through, my lord, the chairman in his capacity as the governor as the capacity as the chairman of the committee has taken the decision to call these 20 persons. But the decision why these 20 persons to be called, that is not on record. But I say that if this order is stayed, my lord, then at least, my lord, I know this matter can be heard out before the vacation. If your lordship is thinking towards stay, in that case, my lord, this institute should be run by some other official in taking in charge of the institute and not by the private respondent. Because I say this because this appointment is only for 3 years. He has already served for a few months before the order was delivered by the honorable single bench. Now again, if he is allowed to continue, my lord, then everything will become infructuous because we don't know when the appeal will be actually heard out. And my lord, the process which has been adopted to select these candidates is vague and non-transparent. And I say, my lord, it is not only the case that where the experience of the candidates were taken into consideration. It was argued before the honorable single judge that the experience, whether the candidate is running a cultural institute or not, that could not have been decided by this scrutiny committee. But it is not the case that only those candidates who were disqualified on the ground of having qualification, not having qualification, has been called before the search cum selection committee. If my lord kindly comes to page 74, my lord, 74 is the list. It's a part of the list of all those 41 candidates, my lord. My lord will find at serial number 8, and I hope it is legible before my lord. Sri Shamaprasad Chattopadhyay, he is the writ petitioner in the other writ petition, my lord. He was declared ineligible on the ground of having being overaged. My lord, he was also called before the search cum selection committee. Therefore, it is not only the candidates who was not having experience in running administrative experience in running cultural institute were called in addition to the 11. Some candidates who were overaged has also been called. Then what was the the criteria of calling these persons? That has not been answered before the single judge. When I say the selection process is totally vague, totally non-transparent, it has been correctly set aside by the Honorable Single Judge.
Yes, yourself.
My lordship.
Briefly.
Huh.
Briefly.
Yes, yes. In brief, in 3 minutes. First of all, I introduced myself. I was the Deputy Director of EZCC in the year 2005 to 2008, 3 years, apart from other cultural institutes. So I know the inside story of EZCC, everything, being Deputy Director out there. Now the question is, first line, Lordship asked, who is holding the EZCC as Director? First question Lordship asked, who is holding the post of Director of EZCC right now? Learned advocate of EZCC told the same person. The person was dismissed. He was quashed on the 4th May. Thereafter is running the office. How? Under which authority? I don't have any idea. But it should not be like that. Because in the past, it happens in the same situation, dual charge by other zonal cultural directors. They take over. Not only that, Ministry of Culture is having 7 directors out here in Kolkata, in the National NISM, Institute of Scientific Museum, Science City. And that director was holding the charge of EZCC for more than 7 months. So like this, it is not that hard and fast rule that the cost director will continue. Even inaugurating the functions after course, live chart, participating in the live chart as director, and like this all going on. But where is the authority? So that's one. Second one, the chairmanship, in their application, they have mentioned that chairman's office is at EZCC. I do not know whether Rajbhavan is shifted to Rajbhavan, Governor, Honorable Governor is the chairman. Whether this Rajbhavan is shifted to Salt Lake or not. Why it is written that his chairman's address is Salt Lake? That is my question. It is apart from that. And third one, from my experience, I am saying, they are saying so many things that whether this is a regular appointment or it is a contractual appointment. EZCC director is always in the past 35, it is since 1985, always a regular post. Since 1985 inception. It is never a contractual post. Number one. Number two is that one that he said only to call for rejected. Why is this one, the Mr. Victor Chatterjee, learned advocate, he told 3 years experience and all these things. Main criteria is his case of Mr. Giri, who is first right now, should have been rejected in advance, at the first instance. Honorable Lordship rightfully asked, the deputation was the answer, but he was holding the post of grade 7, that is very, very lower post, and cannot apply to the post of level 11 through deputation. He is barred, and his application will not be forwarded by the employer at all. So what he took the backdoor entry. He did his employer in the dark. He wrote his fresh application outside the service that I want to join, and if I am selected, I'll retire from the VR. I'll take through VR. This is a manipulation of a service. Said the single judge at the page, this one, that OM prescribed, DOPT OM, prescribed that whoever in the government service and whoever applies for, be it regular or be it contractual, any employment should be routed through proper channel. That area has not been also scrutinized by the scrutiny committee. That was wrong. It should not be like that. Even All India Radio was in a hurry on the 1 day or 2 days to accept his voluntary resignation without knowing it or without questioning any disciplinary proceedings. That is also another aspect. But it was pointed out.
Have you taken all these points in your appeal?
Yes, not in the WPA. In the WPA,
You have filed an appeal.
no, I have filed only MAT,
That is an appeal.
memorandum of appeal.
And have you filed an application in the MAT?
No, MAT, I have mentioned the WPA, but not mentioned.
You have filed. You,
No, no.
1 minute, let us not go by WPA and MAT. Did you file a writ petition
Writ petitions, yes.
before the single bench?
Before the single bench?
Yeah, wait, please
Yes,
wait.
yes.
Then that writ petition, now have you filed an appeal?
Here,
Yes.
here
Now,
is memorandum of appeal.
Correct.
I
You're-
said that the lordship, the judgment is absolutely
Where
correct
is
of
your,
the single bench.
have you filed, you say whatever you have said, understood, we are asking you some technical issues.
Yes,
You have
No.
filed an appeal, a memorandum of appeal.
yes,
You are appearing in person.
yes.
Have you filed an application with the memorandum of appeal?
Only the one para which has gone against me are remaining all 49 paras in favor of me.
But may I just?
So I am not challenging the verdict. I am not challenging I do not want stay order. I want that since with my experience, it was considered by Search-cum Selection Committee and including my foreign service. So give me a chance to appear and to call for fresh selection or through screening test.
May I just
That's
point out
fine.
something? Kindly, my lord, see paragraph 49 of the impugned judgment. His application has been rejected. His writ petition is rejected on the ground that he was an ineligible candidate.
Very good.
So none of the ratio which is discussed in the judgment applies so far as he is concerned.
Ashok. You know, party / are represented in the order of names / names as printed above in the course title. Full stop para. The above 3 appeals appear for analogous consideration. Full stop. Detailed hearing, detailed submissions have been advanced by each of the respective learned senior counsel and the learned additional Solicitor General for the appellants as well as for the private respondent / the writ petitioner. Full stop. There are several issues connected to the selection for the post of Director, Eastern Zonal Cultural Center within bracket EZCC. Several factual and legal issues, EZCC have been placed before this court. Full stop para. The hearing could not be continued today because of paucity of time. Full stop para. Accordingly, there shall be a stay of operation of the order impugned of the Honorable Single Bench up to the 15th of June, 2023, or until further orders, whichever is earlier, full stop para. The present incumbent in the post of director, EZCC, shall only be entitled to discharge day-to-day functions without taking any policy decision till the matter is next heard by this court. Full stop para. Let the matter return under the heading fixed at 2 p.m. at the fixed at 2 p.m. on the 13th of June, 2023.
Would your lordship kindly,
Appeal to you. Let this appeal be treated as on day's list. Affidavits of service filed today be retained. Mr. Chatterjee, this is an interim measure. We intend to consider it further.
But since it was Lordship's desire
Yes.
to hear in detail, would it be Lordship's pleasure to make it part heard?
Yes, yes. What very close to, yes, yes, but
in fact, your lordship has heard it in detail. Kindly, Lord, I join the prayer. Absolutely.
essentially I am trying to deliver all the pending issues which are lying with me
I see.
in different division benches. So, but very well, I'll be able to take on
This
load.
won't take long, Lord. This is a
Well,
very short matter.
Let it appear with the consent of the parties. Let the matter next appear. Yes, Mr. Chatterjee, any part heard?
No, part.
A detailed hearing
No,
has been. Let it appear. Let it also be marked as heard in part.
Much obliged.
Before my lord rises, my lord, well, subject to lordship's approval, my lord, may I mention one matter, that is item number 15 of today's list. My lord, tomorrow I will not be able to come to the court because of medical checkup. Let it be taken up on day after tomorrow. Item number 15.
Someone has to move when the matter is called up tomorrow.
Item number 15, day after, because of medical checkup, my lord,
That will be allowed, but someone has to move on your behalf.
no, today, I
Matter
thought,
will be
my lord,
called
that it will
tomorrow.
be taken up, but second half, my lord, fixed matters are
When
there.
the matter will be called tomorrow, let someone move on your behalf.
আমাদের জায়গায় বসে আছে সকালবেলা ভাইরাল হয়ে গেছে বলবো স্যারটা মেনশন করেছিলাম সেটা ভাইরাল এখানে একটা মামলা ভয় লেগে গেছে
And I'm led by Mr. Bhattacharya, still met. So long he comes, met. Let me start, met.
Paper books are ready.
Yes.
You start. What is the matter about?
The matter is, in short, that according to us, that we are trained candidate having that qualification of special BEd. Where we are participant of a selection process for the post of assistant teacher in primary, which was initiated in the year 2016. Now, all of us having qualification of special BEd. Now, rules permits even untrained candidate to be appointed.
I think this issue is also coming up tomorrow or on the date that
Yes,
same.
36,000.
They are including 36,000. They are including 36,000.
No, they are no. We are beyond 36,000.
Issue is
Beyond.
parimateria.
Jodi
Same issue, trained, untrained. You mentioned in the morning,
No, this is not trained, untrained.
not the same issue.
Not trained, not the same issue. But then if the services of 36,000 go, then what remains of the entire recruitment process?
Who are they?
My lord, they were claiming to be eligible on the basis of their BEd special qualification. But BEd special is meant for teaching handicapped students.
for upper primary.
For upper prime, for up 6 to 8 for upper primary. They are not eligible otherwise. But they claim, my lord, that they should be considered for appointment as primary regular teachers.
Briefly, yes, Mrs. Russell. Briefly, yes.
Now, our case is that even the untrained candidates have been given appointment, whereas we are having qualification of special BEd that they have interpreted the notification of 2010, which was issued by NCT,
Yes.
that we are meant for class 5 to 8 in general school, not in handicap school. That their interpretation is
What matter fix such Huh? There are 3 more matters. So you please limit your time, file your notes of argument. We will conclude the hearing because we cannot. This is 1 week we have, and after reopening, I don't have time. So we are not going to spill over into reopening. If you can complete by today and they can complete, file your notes, we shall take the major points down. Otherwise, you wait for your turn after reopening.
then can fix a date after reopening.
That's right.
It's right.
Because we cannot, to be very candid, I cannot
Follow.
commit myself after reopening.
So we shall come up with a written notes of argument.
Please do that. We are recording an order. Please do that. Ashwin Shah. Budget is for hearing.
Here as mentioned in the constitution. Let the matter appear under the heading to be mentioned. The monthly combined list of June. To be mentioned. Matter is fixed on 12th of June under the heading to be mentioned.
To be mentioned.
12th of June.
Yes. My lord, on the last occasion, your lordships were pleased to consider this is the issue pertaining to single teacher transfer. On the last occasion, if I may refresh your lordship's memory.
All three matters are the same.
Same, the second matter has a slight more facts, but on the same issue of single teacher transfer. Now, my lord, your lordship were pleased to consider the issue on the last occasion.
Yes, how long will you take to you argue? We'll limit arguments with time.
I will, my lord. I
Yes,
will.
how long
But
approximately?
kindly give me 15 minutes.
If we give you more than 50, who appears for the other side?
Dr. Pattu is appearing on
Yes.
behalf of the School Service Commission.
Ask,
He's on legs, my lord. He's coming, my lord.
ask him
He
to
was
come.
present.
Yes,
And Mr. Boishro is appearing for the state. He was there
Mr.
on the last occasion.
take very well, continue.
Yes. Now, my lord, may I draw your lordship's kind attention to the order impugned first. That is of 9th of June 2022.
Yes, this is a policy matter.
No.
You are of course entitled to seek a transfer.
Transfer,
But
right?
how can you have an enforceable right beyond the policy?
No, I'm within the policy. My submission is that the 3rd January 2022 was given effect to in this order, but that has been given retrospective effect. My application was of September 2021. So this notification has no manner of application in my case. Now, firstly, my lords, there is no concept of single teacher either in the transfer rules and the amendments initially. In 3rd January notification came much later, which brought the concept of single teacher. Much prior to that, I had made application. One. Secondly, my lord, I had handed over a copy of the order dated 19th of July 2022 in WPA number 6338 of 2022. In the same identical matter, the same single bench had held just the opposite.
Show us the policy, show us the retrospective effect, show us.
Yes, yes. My lord, may I just show the order first?
Yes, show us the order.
Kindly take the order. It is within the lordship's records. I had handed over on the last occasion. It is of Supriya Noshkar versus the state of West Bengal and others.
Yes.
19th of July 2022, the same issue on the same point almost at the same time, it has been decided by the same single bench that it cannot be given retrospective effect. This 3rd January notification, this single post teacher, because it first came on 8th of September 2021. Now,
so that is one ground.
There is one. I being the similarly circumstanced candidate, in my case, with deepest respect, this 3rd January notification has been given retrospective effect, but for the similar circumstance candidate, the concept of it has not been given. This is one. Now,
Yes.
secondly, my lord kindly appreciates the 3rd January notification itself. page 56 and the legible copy at 56A. This is the 3rd January notification. I would not waste your lordship's time, my lord. I'll draw your lordship's kind attention to the last paragraph. In that event, a single subject teacher makes application for transfer, the school manager from the DIAC about such application, the DIAC will immediately discuss the matter with the Commissioner of School Education, that is CSE. In the DIAC will take urgent step in time-bound manner to search for a teacher on the same subject from nearby and make local arrangements so that the teacher of the other school attends the school wherefrom the teachers has applied for transfer on the days of the week on a temporary basis till such time a permanent teacher subject joins. The DIAC will inform such arrangement to the CSE, who shall inform the matter to the chairman of the commission, West Bengal School Service Commission, President of West Bengal Board of Secondary Education, and School Education Department. CSE will ensure such arrangement in 7 days. Immediately, the DIAC will communicate the arrangement, such arrangement, to the school concerned, and the head of the institution in question will forward the application of the teacher to the DIAC. The DIAC will then forward the case to the commission for consideration. The commission will suitably recommend the case for transfer to the board, and the board will issue transfer order accordingly. This remains in force until further order. So, my lord, this notification has a mandatory provision for transfer upon making alternative arrangement. Now, my lord, kindly see how they have taken departure from this notification, for which I restrained myself from approaching through the 3rd January notification. Kindly take, I have handed over 28th February 2022 document, memo number 17, issued by, this is one example, this is how they are dealing with 3rd January notification. This is of one Tanushree Haldar. It's a 1-page order.
So whatever is the notification of 3rd January does not apply to you.
Does not apply to me.
When did you apply for transfer?
That is of September 2021.
When
And
is
this-
that application?
Yes, my lord. My lord, kindly see, this is the transfer status, page 46.
This was a portal application.
This is how it has been done through the website, because there is, at that point of time, there was no physical application allowed, only through the portal. My lord, kindly see, effective application is of serial number 4, 18th of August 2021, from applicant to the head of the institution. On serial number 3, on 31st of August 2021, head of the institution to the DI of schools with the endorsement.
Your serial number?
My lord, this is my application. I'm starting from 4. Because first application at 6, which was not acted upon, then it was returned in.
So your serial number 4.
This is mine only. This is the stage 1, 2, 3, 4, 5, 6 are the stages of my application.
So you went backward first, forward second, backward third.
No, it is to be seen from 6 because it goes upwards. My first application was made on serial number 6, that is of 18th of August 2021, and then 5, which came backward from the HOI to the petitioner on the ground that certain documents were required to show the distance.
Very well.
Then, my lord, kindly take 4. On the same date, that is August 18, 2021, I applied from applicant end to the head of the institution. Then 3, it was forwarded on 31st of August 2021 from the end of the head of the institution to the DI with the remarks at the right-hand side. Single teacher of our school, total students of our school is 403, and she is only math teacher, students will suffer. Now then 2, DI sends it back to the head of the institution with the endorsement, single teacher in the concerned subject. And then 31st of August, it comes back from the end of the school to the petitioner. So much prior to 3rd of January. Now, my lord, it is my duty and responsibility to show that when the single teacher concept came into effect, page 47. that is 8th of September 2021. After my application was brought into effect. I directly draw your lordship's attention to page number 48. Amendment serial number 5 for rule 6. Substitute the following rules 6 2C.
Page
Page 48, my lord.
48
48.
to
6 2C.
6
2C.
to C.
Consider the numbers of subject teachers and roll strength. If resultant vacancy of school in particular subject becomes 0 or not commensurate with roll strength, the authority of the school managing committee shall not forward the application. Now, my lord, kindly skip a bit and come to the proviso. Provided that while considering such applications, if resultant vacancy of school in particular subject becomes 0 or not commensurate with roll strength, the SMC shall approach the commission through DIC for filling up the vacancy. So, my lord, this also came after my application was made. Now, my lord,
Then
my lord kindly appreciates this provision was given a go by subsequently by the amendment itself. I draw your lordship's kind attention to the page number 53A, which is the predecessor of the 3rd January notification, but not in a statutory form, but in a memorandum form. The similar provision has been laid down under this memorandum, which your lordship has been extremely kind to consider in the notification dated 3rd of January 2022. So this is the replica and the predecessor of the 3rd January notification. And it is given in the 3rd paragraph that how it is to be done, verbatim of 3rd January. Now, my lord, this proposition was changed subsequently. If your lordship kindly takes page 54 by way of an amendment, page 54, dated 22nd of December 2021. All these things are happening after my application, but I'm showing how it has been dealt with by the authority. The relevant portion is at 55A, page number.
but now you may have applied before 3rd January 2022. But the point is, it is being considered now.
No, at that point of time, it has been rejected. So I came before the Honorable Single Bench. The Honorable Single Bench gave retrospective effect to the 3rd January notification, which has no application in my case. At the same time,
No, but you applied then before 3rd
August.
January.
Even before September, when first the
Correct,
concept came.
Correct.
Yes.
That time it was rejected because that was not the whatever the reason it was rejected.
Single teacher ground.
What was the reason for rejection?
Single teacher ground. It was rejected. I shown to your lordship.
Now that it is being considered now presently, this transfer policy will apply. This will you have a vested right to claim a transfer on the basis of a
My lord,
lack of retrospectivity?
my application ought to have been considered at that point of time. Had it been considered in accordance with law, then today I would not have suffered this, because the law applies as on day, not prospectively, subsequently. And I showed to your lordship how this concept has been whittled down subsequently. Kindly take page 55A, 4C. This is the amendment brought subsequently on 22nd December 2021. Consider the page 55A, 4C. Consider the number of subject teacher and roll strength if resultant vacancy of school in particular subject becomes 0 or not commensurate with roll strength. The authority of SMC shall not forward application. However, it shall not be applicable to single subject teacher post for which the state government shall issue separate guidelines. So that concept of single teacher was given a go by subsequently. This is how they have dealt with the issue. Now, I had already submitted the 3rd January notification. And my lord, page 59 is another example, is not one. The same single bench has held that it cannot be given retrospective effect, but only in my case, it has been not considered. That page 5960 I have given. Now, my lord, the same order it has been. Now, my lord, I draw your lordship's attention to page 61 for once. This is the rule. This is the transfer rule from which I show Act section rule 2M, the definition of teacher, whether there was any prevailing concept of single post teacher at all at any relevant point of time in the statute itself. There was no, neither at the time of my appointment nor under the transfer rule under which I have been governed. Kindly see 2M at page 62. This is the transfer rules of 2015. This is the parent rule. Teacher means an assistant teacher of a school recognized as such by the board or council as the case may be, and includes the headmaster or headmistress, assistant headmaster or the assistant headmistress for the purposes of these rules. However, assistant headmaster, assistant headmistress may seek transfer as assistant teacher. So in the definition of teacher, there was never a concept of a single post teacher or role strength commensurate teacher, nothing. This is the parent rule. And I was governed under this rule. Never there was a concept. Now, my lord, on the last occasion, a question was posed to me from the bench that what was the appropriate guideline prevailing at that point of time. There was a guideline beyond the, with incommensurate with the statute that will appear at page number 676 of the application. This is the guideline to application of secondary HS school seeking transfer. And these are the grounds laid down. Nowhere there is any whisper of any single teacher concept. So at the relevant point of time, before the statutory amendments were brought in, the authority imaginarily brought a concept of single teacher, which was neither in the transfer rule nor in the guideline, nowhere. Now, my lord, there is one submission I would like to make before your lordship. What is the concept of Utshosri portal and what is the concept of transfer? There is an often misunderstanding in me itself that whether Utshosri is transfer, but that is not.
Where is the authority that the time when you made the application for transfer, it must be considered at the, for considering the law. You have an authority on the point. Or if the policy changes when your application is pending, it must be considered in terms of the existing transfer policy.
Even at the time of the amendment, my application was rejected. It was not even pending. On a very flimsy ground, which did not exist under any provision of law, it was rejected.
So even if the rejection is set aside, what would be the consideration now? The consideration would be the existing transfer policy or then there will be number of teachers, possibly hundreds of teachers who will say apply that transfer policy.
Yes.
The whole administrative anarchy would result.
I tell your lordship, my lord, the transfer rule, the transfer.
The transfer is being made, supposedly in your case, this is no malafide is pleaded, no motive is pleaded in public interest, in the interest of teaching. So in that event, if there are hundreds of teachers, single teachers all over, they say, please treat us then in terms of that policy, which was pre-January 2022. What will be the administration, then how will the administration perform?
Yes, I answer to this query.
Maybe assuming, sorry to interrupt you, maybe assuming that when the rejection happened under that policy, it was wrong.
Yes. Now I tell your lordship. My lord, there is a that I was trying to address it to your lordship. Transfer policy, transfer rule has not been changed. Transfer rule has remained as it is of the transfer rules 2015. Now, what is Uchshasri? Kindly take page 79 for once. Uchshasri portal was just an online portal to facilitate the transfer.
Correct. It's not a policy. It's
Not a
portal.
policy. Not a policy.
Okay,
Now,
understood.
so therefore, my lord, I'm still governed under the 2015 rules, which permitted the transfer.
So what happened in 22 January? The policy changed.
The
Portal did not change. The policy
portal did
changed.
not change. The policy changed afterwards. But can there, I pose this question to might be given retrospective effect in my case. Now, my lord, one question I must answer to your lordship. Your lordship has very rightly posed a question, what there would be an anarchy if it starts happening. Now, my lord, I tell your lordship, on 10th of February 2023, government has promulgated with a new policy of rationalization of pupil-teacher ratio by giving administrative transfer to teachers to the schools where there is lack of teachers, but students are there. So I have already handed over this policy on the last occasion before your lordship. It is of 10th of February 2023. Dr. Sharma, please. As I was submitting, two things I would be submitting before lordship. Firstly, now the state government is equipped with a policy since 10th of February 2023 that they can send any teacher under the garb of administrative transfer to any school where there is lack of teachers in the schools. So now if I am given, I'm addressing the practicality. If I am addressed on the issue that I am a single teacher, I should not be transferred to the another school or other teachers. I am concerned with my case here. Normally, the state authority has the power today to bring any teacher to that school which is supposed to get the sufferer, to become the sufferer. So today, it cannot be said the school is going to get affected because there will be no teacher. Because from 10th of February 2023, state has promulgated a policy to bring any teacher to that I had already handed over to your lordship on the last occasion.
Yes.
Now, secondly, my lord, we have learned so many occasions which had fell from your lordships on time and again, whatever the consequences are. But when the law stands as on date, we are governed by that. Perhaps the law does not think about the consequences, what will happen, but when I'm governed under the law, it should be given effect to me. Good, bad, indifferent, whatever the consequences. Now, if I consider the consequences that there would be a probable anarchy, perhaps it will not take place because the state has brought a policy of 10th February, if I may refer to that policy, that notification, which says that the state can bring any teacher anywhere under the administrative transfer. So the fear of this whole anarchy perhaps does not stand today because the state is equipped to handle with the situation. So if today it is given to me or tomorrow other 100 teachers come, the state has power. Because, my lord, I cannot vouch for the other 100 teachers because those who have come before the court, it is in personam. It is not in rem.
Yes.
My humble submission. So, my lord, basic application of law and the fundamental principles of law without giving any retrospective effect, I cannot be made to suffer. Then, had that been the consideration, the state ought not to have brought the policy of transfer. They had brought the policy, they are bound by it. So am I. So, my lord, it is my humble submission before lordship that.
So now you have, in the event, you have two options. First option is not the current policy, go back to the old policy. When I applied or when you applied, consider me in terms of that policy. The second option is that currently there are three policies, 22nd January, 10th February, and the other one which you point out. So if they pass a reasoned order and bring it to court, these are the reasons why we can consider you or cannot consider you under the present policy. Which option should we adopt?
My lord, my humble and respectful submission
We
before,
can set aside the order of the single bench, but then when we remand it to the authority, which stand do we take?
my lord, in my
Where is the authority for that stand?
yes, my lord, in my respectful submission, my lord, the authority may not be relegated with this issue because they will come with the same consideration that you a single teacher, it will not be given effect to. Now, my lord, it is for the honorable court to decide whether on the pure applicability of law. Now, as per applicability and interpretation of law, my application ought not to have been prevented on the ground of single teacher, and it cannot be given retrospective effect. So, my lord,
Is here then?
I only one humble submission, my lord. So I should be given the transfer as I applied for. Now, my lord, only one development after all these issues, after even filing this appeal, there is one development that the Uchchasri portal has been suspended temporarily till 30th of June. However, we are not concerned with the Uchchasri portal itself because that's in facilitating software, basically. I am under Rule 2015. Therefore, my lord, in my humble submission, I should be considered and treated under the law as it is. Now,
As
this
it was,
lordship,
not as it is, as it was.
as it was at that point of time, and my lord, what, because if it sent to the authority, my lord, again the whole purpose will be frustrated. Again, they will come with the new policy, this, that, my lord. Again, my lord, I travel 100 kilometers per day to attend the school, and I have a 3 years child. I'm a lady teacher, my lord. That is the consideration, my
How
lord.
long have you been serving?
I've been serving since quite long, my lord. May I just tell your lordship? I was appointed on 2010. So I have already rendered my 13 precious years of service. So I may deserve, my lord, to be considered for transfer. And as a matter of fact, in the latest notification and the policy of rationalization, there is a clause which says lady teachers with minor child may not be considered for administrative transfer. So for this kind of teachers, my lord, the state authority itself has shown some mercy, which will appear in the notification of 10th February 2023.
Yes.
That is my humble submission, my lord.
Item. This is item.
This is, my lord, I am for the school service commission. If the order is, your lordship, my lord, under challenge, it says, my lord, that it has been rejected by the DI. So, my lord, the answerable respondent would be the state. But ultimately, if the state authority allows us, then only we can recommend anybody. But before that, my lord, certain points I must want to. This Uchchasri portal was suspended on 29th September 2022. Before filing, after filing of this appeal. This was filed on, my lord, on June 2022. So at that moment of time, even then, if the reason was bad, the petitioner has, applicant petitioner has that much of, my lord, your lordship's consideration, whether the decision is right or wrong. But at this moment of time, we have 16,000 teachers, my lord, under Uchchasri portal has been transferred. This is a matter of record, either by way of moving before the court or in the application in the app. So, my lord, 16,000 teachers has been applied. Some teachers may, my lord, rejected by the decision that there is a single teacher, the school will be suffering. So, they have challenged. They have a right to challenge. They have challenged. But now, my lord, as on date, on 10th February, we have rationalized the thing. It is stopped because some schools are there, my lord. There is no teachers with huge students, and some schools are there. There are only 50 students, but all the teachers are running to that school. They are applying.
So put her in this rationalized scheme.
That is why it has been stopped, because the students are suffering. But this is I mean, myself also, my lord.
She has a three-year-old child. She cannot be allowed to travel 100 kilometers.
Yes,
Since you want to rationalize it,
yes,
show us how much you can rationalize it.
Well, it is just issued on 10th February 2023, and 600 teachers has been transferred. More than 600 teachers out of certain, well, repetitions has been pending
After rationalization.
After rationalization, 608 actual number. So, well, we are doing it. Well, petitioner can apply afresh to that.
We will ask you to. We'll ask the state, the Commissioner of School Education, to point out what can be done about it.
My lord.
Who represents the state?
Mr. Bhaskar Prasad Boishu is appearing for the state.
Yes. Let the Commissioner of School Education be then. Nobody is for the state, nobody is.
One day was here, my lord. Another matter has been called on the left.
So you be here.
My lord, may I just point out one thing? Perhaps there is a point of convergence, subject to your lordship's
And
can't
another
consider
thing,
it.
my lord, the point of law which your lordship will consider, my lord, in that aspect, my lord, if
You
your
have
lordship-
not been able to show a decision,
My lord,
retrospectivity and
Yes.
prospectivity. As far as transfer is concerned, policy is concerned, can there be a retrospectivity involved? Because there's always a current situation which is being evaluated.
yes, I understand. My lord, perhaps.
Was on authority.
Yes,
on,
my lord, I was.
why have you not come prepared on that aspect
I
of the
did
matter?
not,
Why are you only saying that single bench may be told may be wrong?
Yes. My lord, just only one humble submission. Perhaps, my lord, the situation can be resolved. Perhaps, subject to lordship's kind consideration. Taking into account of the 10th February rationalization policy, if the appellant before lordship can be transferred to any school nearer to her house, then the situation is.
Need the Commissioner of School Education for that.
Yes, then in that case, my lord, the rationalization policy is also maintained. Her transfer is also maintained, and she can also be sent to a school near.
It means you're conceding your first argument. The retrospectivity of 2015, you do not want the implementation.
My humble,
My lord,
my humble submission
what
is.
much of right the petitioner got? Transfer is such right.
My humble submission is in regard to what had fallen from your lordship, whether the rationalization policy, whether the commissioner is to decide, then my lord, it's a proposal from my side, my lord. Perhaps it can be considered if she is given to any near.
Difficult. Only those schools has been sent. First, it will be tried for the same district. Then it will be to the adjacent district, and it will be in the lady teachers will be considered. It is right. All these things, but it has to be done by the necessity of the school, not by the wish of the
No, I'm not saying
petitioner.
wish.
That
I'm
I
not
want.
Say
to
we are
this
on
school.
a Monday. Let
Yes.
the commissioners please come forward. Let the Commissioner of School Education give us a decision by Friday. First half. We give him 3 days. Where she is traveling for 13 years, 100 kilometers. That's all right. But now she has a 3-year-old child. After vacations, we do not know whether we assemble again or not. So we are directing the Commissioner of School Education to apply the policy as existing and give us a decision with regard, considering her convenience also.
Yes. And my lord, in district of Hooghly, she belongs to district of Hooghly. There are several schools
She'll be given an opportunity of
choosing in the
hearing.
Hooghly.
Let her point out whatever she has to point out, apply your rationalized policy
Then, my
for
lord,
the commissioner and come back to this quarter.
my lord, if your lordship, my lord, kindly, my lord, do one thing, my lord, keep the matter pending, because
Yes,
the
or
question of
Yes.
which rule will apply, my lord, that will carry to other 2 cases also.
We'll
Perhaps
come to the other 2 cases separately. This case has a
Yes.
particular bearing.
As you
A
know.
3-month-old child and 100 kilometers to school, 100 kilometers back. So this case has a particular bearing. We are asking the Commissioner of School Education to report through State Council by Friday. Otherwise, he personally appears and explains the position. You make it.
yes, my lord. Well, 100 kilometers to and fro. 50-50 kilometers. That's also
50-50.
Yes. To and
My
fro.
lord, the petitioner applied because it is more than 25 kilometers.
That
is
was in the
already-
rule.
That is already in the rule.
Yes.
So it's 50 kilometers. That is why it's
Beyond
And
25
there are
kilometers.
judgments, my lord. My lord, I have to show. But petitioner is getting house rent allowance. So, my lord, it is not.
That is not.
That is
the
not an
issue.
absolute right that he will have that 100 kilometers. I cannot. Then it will be. It is not that 100 kilometers commission has appointed him as a punishment because of his rank or her rank in the
Yes, yes,
panel.
yes.
That is why he has been posted. Those who ranked top, they are getting the facility of their own. If it is not vacant, what the commission will do? My lord, if your lordship, my lord, direct the commission to consider within, in terms of 10th February, then only it can be. My lord, it is a policy of the state to, my lord, for the students. It is not for the wish of the
No,
petitioner.
perhaps I am saying the same thing in a different manner.
No, my lord,
It is the
it is
10th
not as a matter of right that I have 3 years
I am
old,
not
but
seeking-
petitioner is getting house rent allowance. There are judgments also. If the petitioner is getting house rent allowance, why not he go there and stay? For the students, there are also 5-year students are my lord, teaching in the studying in the school.
Well, what
They have
my
to consider that.
what my learned friend is
My lord, I understand.
my
my lord,
learned
I
friend is
understand
submitting that
I
is to
understand
be
the
the
agony of the
HL
petitioner. My lord, that-
the HRA is to be integrated with the transfer policy then. It is not yet. That is the difficulty. The rule says any school in the district of Hooghly, well, that would serve the purpose because there are other schools because only appreciate.
Enough.
Yes.
Mr.
But
Bishop,
lordships,
she has
as
a
per the
three-
lordships.
she has a 3-month-old child. That is
Yes.
the only reason we want the
But lordship,
commissioner.
everywhere the 3 month lordship. I
Yes,
it is not the
yes.
first case lordship is the here lordship.
Yes.
This is not a first case. Every lordship, mother is a cancer, all lordship, husband is a cancer. Everywhere lordship, I am lordship. I am submit lordship. Every time I read a petition lordship, it is a 3 kilometer or 150 kilometer. Every person who want to come to Calcutta lordship or anywhere in the nearest. But lordship, it is lord. If the lordship say what is the position and director the commissioner, but I have no scope. If the lordship, any lordship or petition has been lordship, I have considered. Lot of lordship with the division and pass the order. Please the consider the my case. Everywhere lordship the floodgate is open. If the lordship, I am consider the lordship.
Yes.
The floodgate is and the single bench say when the division bench consider the what can I do?
Oh,
Yes, you
yes.
consider the case. So lordship, I am submit.
Then let us do one thing. We understand. We
But
understand.
then our problem is
You have to run an administration. And use only on the facts of this case. Ask the commissioner under the new policy you have, rationalization policy, take instructions, specific instructions, whether something can be done or not.
lordship.
50 kilometers can be reduced to somewhere nearby.
Lordship.
It's not a matter of right.
Lordship directed me. I am deeply obliged, lordship, within lordship, after vacation, all lordship people.
before
Let us-
vacation. My lord, kindly make it before vacation.
Let us meet, can we meet on Friday for this?
Lordship, it is not possible, lordship.
My lord.
Lordship is Friday,
It will be
today is the
difficult.
lordship, Monday. Lots of lordship, 10C matter is going on in the division bench, all lordship.
Another case is also
Lordship,
going on, my lord.
10C
regarding
matter is
transfer.
going on in the division bench,
What
lordship.
matter, what
My
matter?
lord, this
10C administrative ground, lordship, transfer of the
transfer on
administrative ground.
ground.
That
That is
lordship division
608
bench matter
teachers.
is going on, lordship, fixed out 2 PM. Otherwise, lordship, if the lordship single one division bench pass the consider the matter,
Even
whether
matter went
that
up to
lordship,
the-
I have wait for the Wednesday. Wednesday, what the order has been passed before the division bench, Justice Harish Tandon prescribed the division bench. Thereafter come before his lordship, what is the position, and lordship directed me to
What is
consider the
what
commissioner of education.
what is the point before that division bench?
That lordship administrative ground. Administrative ground, Supreme Court say all of the High Court or Supreme Court have no jurisdiction to interfere in the 10th administrative ground. Otherwise, his rule is violated. That lordship, here lordship, that's lord 10C matter is going on today. Lordship said
What
to
is
lordship,
10C?
lordship,
What is 10C?
10C administrative ground lordship.
Transfer-
Transfer for the administrative
My
ground.
lord, the virus has been challenged.
Iris has been challenged.
Virus has been challenged. My lord, that
Of 10, this applies here also.
No.
this is not applied. This is her application for transfer in the Utsos
This
portal.
10C is applicable to
Administrative.
school teachers.
My lord,
10C is applicable to school teachers also.
school
Yes,
teachers,
yes, yes,
school
yes.
teachers only
Yes.
under the my lord, School Service Commission Act.
And that is under
That
challenge.
has
before-
that has
Challenged
went
by
up to the
That matter
Supreme
went to
Court.
Supreme Court. Supreme Court returned back to
Supreme
the
Court
trial
no granted
Division bench.
injunction.
Division
Even
bench
granted
hear the
back. My lord, petitioner directed the
hear the
petitioner
matter.
to join.
That lordship, lots of matter heard by the single bench, Justice Basu and Justice Anuruddha, division, single bench matter referred to the division bench, all matter
Assigned.
assigned the division bench. That matter all hard,
So 10C is
that
relating
advocate
to,
generally argue the matter, lordship.
10C relating to
10C.
school teachers.
Yes. My lord, it is.
So lordship, I am
court to
difficulty.
decide.
Transfer on administrative ground.
Lordship.
Yes.
This is also denial of transfer on administrative ground.
But under Utsos portal, this is different.
No.
Yes, you
It-
applied on Utsos portal.
Kindly, what I'm submitting.
Hmm.
10th February is under 10C itself. It is referred. I should clarify this.
The 10C there little matter is.
No, no.
Reason based.
This is a policy. 10C is different.
So what policy? 10C matter.
I do not know why this it has already been done.
So by Wednesday, no final decision will come.
Lordship, today matter was heard before his Lordship, Advocate General argue on matter. Lordship, some queries were there. Lordship directed the Advocate General, also the petitioner to come at Wednesday. The matter will be
Then
heard.
let us meet
This
after.
policy is not under challenge. Only Section 10C of the 1997 Act is under
So
challenge.
Lordship, that's my
This policy is not the 10th February policy. That is of 2017. 10C
If
came
the
in
Lordship consider
2017.
the matter, Lordship, that
It is
floodgate
different. It
open
is
and
no
single
floodgate.
lady
It is for this case.
So no, Lordship.
no one
This
has
is
come
what
before your
difficulty
Lordship.
This Lordship.
My lord has seen in the same case, different order was passed. The same single bench allowed it and
Pass
did
the
not
order.
allow
Now the
this.
single bench is not entertainment that petition, Lordship.
Yes, I'm saying that's why I have come.
That
Because it
interpretation
is not in
interpretation.
my case, it is being allowed. Not allowed. Others have been
Earlier,
allowed.
Lordship, Justice Mantha passed the order. Thereafter, Justice
I
Mantha
do not
rejected the
understand why they cannot come with an instruction when 2 days. It's my humble.
Where is 10C? Do you have 10C
Yes,
with
yes,
you?
yes.
Yes.
I'm just,
Show us what is 10C.
yes, my lord. But kindly give me a moment. I'm just.
NC Lordship, to the administrative ground, Lordship. না, আছে তো।
না, আমার কাছে
আমি দিচ্ছি আমার কাছে আছে।
DI challenge. DI করেছে। Single teacher reject করে যেটি order under appeal এটা শুনানি হচ্ছে। বুঝতে পেরেছো? আমার কাছে যদি বলেন আমি একটা রিপোর্ট
My lord, may I just hand over 10C? আমি দিয়ে দিন বইটা একটা।
একটা দিন না
একটু দিন, একটু আগে দিন।
আগে একটা দিন তারপরে জজ সাহেব
চাইছে।
পাতাটা খুলে দাও। এই পাতাটা খুলে দাও।
এই
But
পাতাটা একটু
single bench passed the order to consider the district inspector of his school.
single
Order
bench.
under
So
challenge.
Lordship directed the same order has been challenged. And Lordship directed the
Yes.
Commissioner of Education is challenged.
Mr. Lahiri, kindly see paragraph 6 of rationalization policy.
Yes, yes, it is. in
After
refer-
getting the proposal by invoking the provision of administrative
Yes.
transfer. That is section 10C of the West
Yes,
Bengal.
yes.
Then
Yes. Yes. My lord, my argument
ultimately
is
this,
not based on 10C. 10C I showed, I mean, বলে নিন, আপনি তো বলছেন।
ফেব্রুয়ারিতে
It's a query to me, please. My lord, my submission was 10C. My submission is not based on this notification. My submission is that it should not be given retrospective effect, the then applicable notifications. I only showed in case the state is,
10C বলেছে।
my submission was in case the state is suffering any difficulty for the school, they may have exercised power under this provision. So my substantial submission is not based on this notification.
Ashok,
It is only to show that they have an authority.
come back after the school, after this court reopens. We do not know what is the effect of 10C on this.
My lord, this 10C may not have been taken into consideration.
How not? Why not?
Yes.
Look at this, state government to issue guidelines to the commission. So these
Yes.
guidelines are there, then
Yes.
10C will be an additional guideline if as the court will
Yes.
decide.
Yes.
So how can we say only insist on
Yes,
this?
I tell you, lordship, say, rule 2015 gives the voluntary power to the applicant to apply for transfer. This notification or 10C gives the power to the state. So these two separate avenue of transfer. So my submission was this notification only to show that the state has power to fill up any school which is suffering due to lack of teachers. It anyways cannot have retrospective effect in my case. So that was my humble submission. My submission was not based upon this notification. My submission was very simple, that at that point of time, single teacher concept was not there.
There is no.
And 10C does not deal with single teacher concept. That was my humble submission. It is ancillary submission to my substantive submission.
Mr. Bashir, when will you be able to come up with a proposal as has been suggested by his
But
lordship?
Lordship, as per if the Lordship directed me, I am a humble Lordship. Now, after vacation, I will come, Lordship. Without Lordship, before vacation, Lordship, Commissioner of Education. But here, Lordship, single teacher, Lordship. Everyone we have difficulty, everyone the single geography teacher. Where the DI wrote a letter to the 4th to 5th school, please give. There is a school reply, I have not any teacher. But I have tried to my best level. I have notification has been made. Ki I have DI tried to best level to the consult with the CSE, Commissioner of Education.
Reference on assignment, you put a single page, we have a copy.
But Lordship, here the Lordship, that Lordship.
That's, the other division bench, which is hearing 10C, what is the reference, the terms reference on 10C?
10C difference আছে তো?
না এখনই নেই my lord,
But
I
here
can-
and now, Lordship, I just within 15
day after
day after tomorrow, Lordship, tomorrow.
Not this side of the vacation. We are also under tremendous
Yes, yes.
thing. We have given him a date and we'll
Let's
give you a
say
date.
May I
just
just
after
suggest
the-
one thing? May I just suggest one thing?
Lordship, after vacation, it is
Just
possible
one
to
suggestion.
speak with the Lordship.
Well, may I just suggest one thing? 10C is not the issue in my case.
You may say so. We may
Yes.
disagree with you.
petition
Yes.
is relying on
It is
10th
no, what I'm submitting, my lord, 10C I showed to show that the state has power. Now, only if your lordship decides that those 3rd January has no retrospective effect, then my case is determined today.
So we decide that against you because 3rd January,
Yes.
we cannot say a policy of transfer unless and until you show us an authority cannot be decided at the existing position. Because if a policy of transfer changes, the administrative policy also, when you are to be considered, then other teachers are there. They might say before that we should be considered. The state has changed this policy, has rationalized this policy.
Right.
State, we think, subject to that, it's not your date of application, the date when it is being taken up for consideration, even if that rejection was wrong.
It was rejected before the change of the policy.
So show us the authority.
Very well, I'll come on the
Come
next
with the
step.
authority.
Very
Okay.
well. I'll come.
You bring in forward.
Lordship, I am cited the 4 to 5 judgment, Lordship, the Supreme Court. Supreme Court say administrative ground without any rule, violation of the rules. High Court, including Supreme Court, or no jurisdiction to enter the matter if the rule says it violation, Lordship.
Question is this. Mr. Lahiri, of course, he is defending his client. We appreciate that. He has two options. One is he must stick to the point that pre-January 2022, what was the
Lots.
policy? But we have not been shown any authority. Because we believe that the transfer is as per existing policy. Because that is how all teachers can be taken together, even though the earlier rejection was wrong.
Yes.
Now, if that is the position, then there is a rationalization.
Yes.
And there may be 10C. Now, with the rationalization, we wanted the commissioner to apply the rationalization to this teacher and come up with a solution. Now, only thing you can do that and come up with a solution after vacation. In the meantime, we'll see how the 10C works.
We will apprise also, my lord, what happening in the.
In the 10th. Thank
Yes.
you.
Great.
Seven June. Witness to mention matters. Mention matters. Parties appear as mentioned in the constitution, learned counsel appearing on behalf of.
Mr. Lahiri, you are a counsel who is applying his mind, who is coming prepared. We really appreciate your arguments and everything. But this requires an authority.
My lord, I will
Okay,
assist you,
but
lord.
this requires an authority.
Yes, I'll
Otherwise,
assist
we cannot agree with you.
I will
So
assist
we are
you, lord.
still asking them to, but you do not have to forsake your point.
Yes,
Come up
yes,
with
yes.
an authority. We'll give you a date. 7th of June, we are giving you a date.
My lord, I'll come with the authority, my lord. Well, I am sorry, my lord, I
it's all-
thought,
Hearing of the appellant. Submits at length. Seeks an
Lordship,
opportunity
give me
to
a-
advise his court.
Lordship, item কত number? Four. Lordship, item number 4, same identical matter, Lordship, same Lordship.
So also I am appearing.
So Lordship, I am telling my junior is here, Lordship.
Authority on the aspect as to policy, the policy to be adopted. Full stop. Mr. Oisho, appearing from the state, submits the according to at this present moment. The policy being adopted by the state transfer. A policy of transfer which is being adopted by the state is the rationalization policy, according to which the student teacher ratio is being taken into consideration. First one. Paragraph. In this, considering the submission of the learned Mr. Boisho, appearing for the state, is directed to come up with a proposal considering the policy of rationalization in view to come up, just equivalent to come up with proposal rationalization. Full stop. Let the matter appear. Let the matter appear on 7th of June under the heading mentioned matters. The matter will appear on 7th of June. You are to bring the authority.
Yes, yes, I'll try my
Stressing upon
yes, yes, yeah.
since and
My lord, at 2 p.m. your lordship is fixing at 2
My
p.m.
lord,
no. Under the mentioned matters, mentioned matters on 7th of June.
Very well, my lord.
And the state is to produce the policy considering the rationalization aspect. Only with respect to the petitioner.
no.
Commissioner's report to be forwarded by you. Commissioner's report to be forwarded by you.
My lord, we will apprise, my lord, the 10C position, what is happening in the division bench up to Supreme Court, it has been went up to. Then it has been remanded back without any injunction. We will all, my lord, place.
In the meantime,
Yes.
what his lordship has directed, the
My-
Commissioner of School Education will apply the rationalization procedure to the facts of this case. And then we will test it, whatever happens in 10th.
Yes.
And my lord, one information, this notification, 10th February has also been challenged before the Honorable Single Bench. Honorable Single Bench has not stayed this and sought for the information that how these 600 teachers have been transferred. That is the information. And
Yes. That is
Right,
also
so-
matter I am appearing, yes.
yes, he's also.
You focus on your case.
Yes, I will do that.
So that both things cannot be done. Petition
Yes.
relying on 10th
Are
February.
you arguing a public interest?
No,
litigation or
Sir,
your
I'm
case?
just informing your lordship on that.
Deeply. Sure.
Well, I'm for the appellant in this
My
matter.
lord, 4 your lordship, 2 and 4, my lord, your lordship can leave us same order. My lord, kindly.
2 and
Both-
4, same order.
2 and
2
4.
and 4 same order.
Same set of parties are appearing.
Yes, same set of.
Yes, same set of.
Same order. Fourta Dakun Ekbar. Yes. So 2 and 4, same order, separate orders.
Separate.
Next, 3 ta Dakun.
Three.
Order টা same আছে তো?
Three.
Order টা
Yes,
same আছে?
Lord, I'm for the appellant, my lord. This is the same line, but more interesting facts involved.
Why is the state walking away in 3?
I am not there. Mr. Boisho is probably also.
Oh, School Service Commission.
Yeah.
In item 3,
Three.
School Service Commission, you are there.
And let me talk
State is not necessary.
Mr. Boisho is not there as far as
Very well.
State is the necessary party, my lord. State is the necessary. Main
No.
answering
We
respondent-
cannot hear you.
Main answering respondent is the
No,
state,
no,
my lord.
Commission
It
is also,
remains. Sit down,
commission is also there.
see what can be done with the whole.
Yes,
Yes, what is the point?
yes, my lord. My lord, in this case, the appellant before your lordship was a assistant teacher of a school. There was a zero enrollment. In that school, there were no students at all. So the appellant before your lordship was teaching in that school. Now he has been temporarily shifted to a school, nearby school. Since in the parent school, there was no students and he was discharging his service. In the meantime, he made an application for transfer, but his transfer was rejected on the ground that he has not completed 5 years service in the existing school.
Yes.
Now, my lord, first of all, the petitioner, the appellant was prevented on the ground of same single teacher. Now, my lord, single teacher in which school? In a school where there are no students at all. So this is absolutely fallacious to restrict a teacher from obtaining transfer on the ground of single teacher where
There are other teachers in that school.
there are other teachers in the school, but no students.
Then,
These are called zero enrollment schools.
then
My lord, he was shifted
what
to
happens with these schools? Salaries are paid and there are no students.
no students, for which these teachers are temporarily shifted to nearby schools to render their service where there are students but lack of teachers, which is a temporary arrangement which has been done for him as well. Now, usually what happens, these zero enrollment schools are merged with the nearby schools because there is no existence itself on paper itself, because in practically there are no students. So what happened, my lord, he was shifted to a nearby school to render temporary service, keeping him in the payroll and the employment of the parent school, which is the zero enrollment school. Now, when he applied for transfer, he was rejected initially on the ground that he is a single teacher. Now, the question arises, he is a single teacher in respect of which school? Single teacher means there is abrupt pupil teacher ratio. Now, when a school does not have students at all, then the fallacious consideration of single teacher may not arise, cannot arise.
One cannot be equal to zero.
Zero. On that ground, he was prevented first. Secondly, when he again made an application, he was prevented on the ground that he has not completed 5 years in the school, which is incorrect, because the transfer rule says an incumbent has to at least stay 5 years in the school itself. Now, what they committed the mistake, they considered the school where he was temporarily shifted. They considered his employment in that school and counted 5 years.
Correct.
Possibly not, because he was temporarily shifted but not transferred. His parent school remained the zero enrollment school itself. So his candidature of that school has to be taken into consideration, which is much more than 5 years. So the order says he's not transferred for a temporary arrangement. He was rendering his service over there. So on that score alone, he was prevented. Now I draw your lordship's attention. My lord, kindly see page 48 for once of the application. This is the temporary arrangement.
Where is the policy?
Yes. Policy, my lord, there is in the transfer rule itself, there is a provision of reallocation. There is no temporary posting, but they had done it.
5 years. Where is that policy?
Yes, it is in the transfer rules, my lord, itself. Lord, I'm showing. May I please 48 for once? 4th of January 2021, page 48. Placement of service, not transfer. Placement of service of the teaching and non-teaching staff of following schools having zero enrollment as reflected in Banglar Shiksha portal on purely temporary basis. In the interest of education and teaching learning process, the following teaching and non-teaching staff as mentioned in column 1 presently posted at different schools as mentioned in column 2 are hereby posted at the school as mentioned in column 3 on purely temporary basis. Your lordship may find my name at serial number 4. From the Howrah Jogendra Sriti Shiksha Mandir, I was temporarily posted at Shatoshi High School in the same district. So, my lord, my parent school did not get dissolved. It remains the same for a temporary period. Now, my lord, I joined also as a temporary arrangement. Kindly take page 49. The parent school releases me as a temporary arrangement without severing the master servant relationship or employer-employee relationship with the parent school, page 49. This is the parent school which writes, I do hereby release all following staff, 4 assistant teachers and 1 group D from this institution purely on temporary basis to join Shatashi High School on 16th of January 2021 as per order of the DI. So it was a temporary arrangement. Now, my lord, I applied. My distance is 64 kilometers to and fro. Now, my lord, I applied for transfer and kindly take page 59 for once. The same process, my lord, from the bottom, I have to show to his lordship how it has been done. My lord, kindly see 13th of August 2021, applicant makes the application to the head of the institution. 19th of August 2021, head of the institution sends it to the DI with the endorsement that as per the application of concerned teacher, I forward this matter for further procedure. On 19th of August 2021, DI sends it to the commission with the endorsement transfer application may be considered. Now the commission returns on 2nd of September 2021 to the DI saying prayer is returned in cases where there is a single teacher in the concerned subject. Now then, my lord, kindly see, it returns back to the applicant. And 26th of September, again, the petitioner made the application, which returned to him on the same ground that single teacher clause applied for the previous application by the authority. So, my lord, in school where there is no student of 0 enrollment, the concept of single teacher does not arise. But I was prevented on that ground. Now, my lord, another striking feature is that I was supposed to be transferred as per the transfer provision. I was supposed to be transferred at an equivalent position. I have been substantially appointed, but I was sent to an additional post, which cannot be done from the notification itself.
Where is the rejection by the authority?
Rejection is the status. It is all done in the web portal. Rejected, DI sent back to the commission, sent back to the, as I showed. This is how it is rejected. This is the Uchchasri portal. This is how it used to function. This is how it has been rejected and returned. Now, my lord, kindly take page 61 for once.
Yes, the order, the direction for rejection cannot survive single teacher clause. That's all.
That's all.
That's all. And 5 years is not a situation, not a ground for rejection at all.
No, 5 years is a ground that a teacher has to stay 5 years in a school where he is appointed.
Correct.
Not temporarily shifted.
Correct.
So he has to.
So where does the 5 years come at page 59? Nowhere.
Nowhere. It does not come.
How do you bring in 5 years?
Yes.
From where do you bring 5 years now?
I'm showing to your lordship.
If they are not talking about 5 years, why are you talking about 5 years? You're entitled to transfer based on an appreciation of the single teacher comp. And we are prima facie with you on the subject.
Very well, my lord.
Then how does 5 years come in now?
Then, my lord, I restrict my submission to. I'm just taking one moment from your lordship. I'm begging one moment from your lordship. That, that is.
School Service Commission,
Kindly fix this matter with other two matters on this 7th, my lord.
yes, state you are there.
This one.
Number one, there is a,
I am not there, my lord.
we'll keep you there. You're junior to Mr. Vaishru.
Yes.
And you're in the state panel.
Yes.
Good. So give your name, we will engage you there. The whole issue is, number one, he is treated as a single teacher. It's a zero enrollment school. He cannot be a single teacher. The 3 points. Therefore, this part goes at page 59. Fourth part is 5 years. Substantively appointed. Not the school from where he was temporarily shifted. So that is to be counted from there.
Right.
That fourth point goes. The last point is that he has to go to a school. If he has to go to a school in terms whatever he wanted, to the substantive post to which he was originally appointed in the school. So you ask the Commissioner of School Education to come back on the 7th with a proper idea on this also. That's all.
Right.
Ashwin.
A
Copy of the
5
appeal
years
may be
One of
served.
the
5
Stay
years
application may be served.
is counted from where he is seeking transfer, my lord, as per rule.
He's seeking transfer from his substantive school.
Yes.
May I be
It
permitted
cannot
to
be
read
otherwise.
one section, my lord?
Please.
Primary condition for general transfer. An incumbent shall be eligible for general transfer only if or she is confirmed in her service and completed
Page,
5 years
madam.
of satisfactory service.
Madam, page which you're referring to, which page? No, of your brief, which page are you referring?
It's a rule, my lord.
I'm handing over the rule. I'm handing over.
2015. 3.
এটা একটু দিয়ে দিন না, একটু দিয়ে দিন না। চাইছে।
পেজটা বলে দাও।
পেজ নাম্বার হচ্ছে 620 ভলিউম 1। তুমি কত দেখাচ্ছ? রুল 3?
রুল 3 টা দেখো।
তাই তো বলছি, ভুল কি করে বলছো? যে স্কুলে যাবে সেখানে 5 বছর হবে কি করে?
না,
যেখানে
from
আছে সেখানে 5
from
বছর।
where he is seeking transfer.
হ্যাঁ, তো সেখানে
Previous school থেকে না।
হ্যাঁ, প্রিভিয়াস স্কুল থেকে যে 5 বছর শেষ করেই না সে যাবে অন্য স্কুলে। কি বলছো?
তুমি এই স্কুলটা তো কাউন্টিং এ নিচ্ছ না যে
এটা তো হবে না, এটা টেম্পোরারি অ্যারেঞ্জমেন্ট।
Rule 3, my lord.
What is rule 3? Read it aloud.
May I hand over?
Read it.
This is a primary condition for general transfer.
Yes.
An incumbent shall be eligible for general transfer only if or she is confirmed in a service and completed 5 years of satisfactory service in that particular school and in a particular post from which he or she seeks general transfer, my lord. In the case of the petitioner, the present school from where he is seeking transfer, in this school 5 years shall be counted, my lord.
Zero tolerance.
Zero enrollment.
The zero enrollment school.
Yes.
It will be the zero enrollment school because his name is on the rolls of that school. He's on temporary assignment to this school. So therefore, the question is, he is just fulfilling a duty in that school on special assignment. But his name continues to be there. And I think you get paid from the exchequer of that school.
At that point of time, yes.
Where is the order of temporary assignment?
Yes.
So you have a point, madam, may not be applicable to the facts of this case. We'll ask the commissioner to look into that.
Yes.
Show us the temporary assignment order.
Yes. Page 48, my lord. Page 48.
প্রথমে আমরা তাই দেখেছিলাম অ্যাডমিনিস্ট্রেটিভ গ্রাউন্ড ট্রান্সফার
Ashok. A detailed order. Officer of School Education. বলো না।
Not interested in. Even.
Please take your seats.
Thereafter, the appellant applied for transfer. Appellant applied for transfer. Applied for transfer. Application made by the appellant for transfer was rejected on two grounds. Firstly, on the ground that he was a single teacher, and secondly, on the ground that 5 years has not been completed by him in the said school. According to the learned counsel, a school having zero enrollment, according to the learned counsel, in a school having zero enrollment, the concept of single teacher cannot be applied. Full stop. He further submits that as regards to 5 years of continuous service is to be taken into consideration from his parent school in which he was initially appointed, that is the zero enrollment school. Relying on these two facts, the learned counsel prayed for allowing the instant appeal to stop. There was a learned counsel appearing on behalf of the School Service Commission seeks an opportunity to apprise this court on the next date. Full stop. The School Service Commission paragraph is directed to apprise this court of a report on affidavit, considering three aspects. Full stop. First of all, a teacher, as to whether a teacher being temporarily placed to another school from a school having zero enrollment, whether he can be treated under the category of single teacher concept. Secondly, as to the 5 years, the continuous service of 5 years concept can be
applied in the instant case where the teacher has been transferred on temporary basis to another school from a school having zero enrollment. Single teacher.
I don't substantive posted here.
The report is also to include as to whether last line the appellant has been placed in the temporary on temporary basis in a school in a post which is below in rank, in which he was holding in the substantive post, মানে initial school, ঠিক আছে, initial at first school, ঠিক আছে, whether a teacher who was holding a substantive post can be placed on temporary basis to a post which is below in rank to his substantive post. Considering the report is to be furnished considering all the three aspects as stated below, as stated above. The commission is to furnish a report on affidavit on on 7th of on the next date of hearing, that is 7th of June, under the let the matter appear under the heading mentioned matters on 7th of June. The matter will appear on 7th of June under the heading mentioned matters.
Yes.
And the report has to be furnished considering the three aspects which has been stated by his lordship.
My lord, my lord. So, my lord,
Your appointment is being regularized. Grateful.
Serve a copy.
I'll today, my lord. My lord, 2, 3, 4 together. These three matters will appear.
2 and 4, 2 and 4
and 3.
An earlier order has been passed. This one is in respect of only 3. Item number 3.
Very well, my lord.
May not appear as 2, 3, 4. May
Yes.
appear 2, 4, 7.
2, 4, 7. Yes, very well, my lord.
Vimol.
Yes.
I would preference, my lord. Some preference. I prefer some preference since your lordship heard this matter extensively. I'm grateful to your lordship, extremely grateful.
But I appear for the university.
Lordship, additional stamp report are reporting mentioning defects regarding filing of Wakalatnama, Lordship. This is transfer brief. I have already filed Wakalatnama in the CAN application, Lordship. The defects regarding filing of Wakalatnama, I have already filed Wakalatnama. This is transfer brief. In the CAN application, Wakalatnama has already been filed. And regarding expunge the name of the appellant number 2 and 3, I have already expunged, and I am submitting the corrected copy before this court, Lordship.
The same order as in that other matter you want.
Yes, Lordship.
Where is that order? File the corrected copy first.
Lordship, I have to.
Lordship, may kindly have a look to the order.
হ্যাঁ
এই orderটা। You have received a corrected copy of the cost title.
No, my lord. Yes, yes. I stand corrected.
service cost.
2 and 3 expunged.
2 and 3 expands lordship. Similar order lordship like
দিয়ে দিচ্ছি।
দিয়ে দিয়েছেন?
You are similarly circumstanced.
Yes, lordship.
MAT 444.
Yes, lordship. Only the admitting in the civil engineering course.
We cannot
Same.
follow you.
Similar lordship.
Identical or similar?
Identical.
কোর্সটাও সেম তো? কোর্সটাও সেম তো?
না কোর্স স্টাডি তো
এটা বলো।
তো সিভিল ইঞ্জিনিয়ারিং কোর্স
Course is civil engineering in the present case.
সিভিল ইঞ্জিনিয়ারিং
Course
কোর্স
is?
সিমিলার
Civil engineering
And what was in that case?
in
similar lordship as 2017-18 guidelines that is provided in this case also.
আরে বাবা তোমার
Similar guidelines lordship.
কোর্সটা কি ছিল?
ও সিভিল ইঞ্জিনিয়ারিং ছিল
ও
ও
বলতে
গিয়েছিল
হবে না, ঠিক করে বলো।
অর্ডারটা কোথায় গেল? অর্ডারটা কোথায় গেল?
5th semester examination has started.
Yes, lordship has already been concluded, lordship, during the period of 16th February 2013-23 to 1st March 23, lordship. On a special basis, lordship, the appellant earlier occasion was getting chance and to appear in the 5th semester examination, lordship, and get registration by the university. Order 4-4 এর orderটা 4-4 এর orderটা
Special পরীক্ষা। দেখুন আপনি এটা। এই তো।
guideline করে 17-18 দুটো করে দেবো।
6th semester admission plus পরীক্ষাটা স্পেশালি ওর জন্য এর জন্য যখন হবে ওর জন্য এর জন্য all the other particulars are the same.
Yes, lord.
So this order we will say will also govern this.
Yes,
Lordship.
Any difference?
nothing.
No, my lord, nothing different. Well, my submission is also almost same.
Only course to be mentioned as civil engineering 2020.
Same college.
Same.
You're for the
Same
university.
For the university.
You've served the college.
Yes, lordship.
Where is the affidavit of service?
Service-টা কোথায় গেল?
You have to arrange for examinations for these candidates.
Yes, my lord. In case of a candidate in MAT 444 of 23, special arrangement has been done, my lord.
So this will also.
Yes, lordship. It will be done.
That course was in respect of MAT 444 of 2023.
Yes.
The course which was being taken up by the said appellant was
Well, a special arrangement has been done.
the course in that MAT.
My lord, I cannot follow your lordship.
In this list, the course which has been taken up
Earlier
by the
occasion I
candidate,
have
Tara, tara.
filed
is
the affidavit of service.
And
civil engineering.
yes.
In that course, which was that course, which was taken up in the MAT 444 of 2023?
Yes, lordship.
That was also engineering course.
Yes, lordship.
What is the difference?
This is civil engineering course. Similar, lordship. B.Tech engineering course and this is civil engineering course. That was B.Tech engineering course. It is civil engineering course. Both are engineering course and under same guidelines.
না বিটেক বলা নেই, আন্ডার গ্রাজুয়েট বলা আছে। হ্যাঁ একই বিটেক তো কিছু বলা নেই।
civil particular exercise.
Learned counsel,
Engineering.
learned counsel, have you gone through the order which has been passed in MAT 444 of 2023?
My lord,
You have gone through?
yes,
The order which has been passed in 444 of 2023 will guide this.
lordship,
MAT. So
lordship. My submission, the submission which has been rendered on behalf of the university in 444, I am also rendering such submissions, my lord.
and the order will be similar.
Yes, yes, yes.
Who is appearing for the college? Who is appearing for the college? Who is appearing for the college?
On the last occasion in MAT 444, principal appeared in person.
Yes, in person. Nobody.
But today I can't find anyone. Lordship, there was a direction for
Affidavit of service earlier occasion.
there was a direction for affidavits in the last portion of the order. Lordship may kindly held that.
You have filed the Wakalatnama.
Wakalatnama regarding filing of my no objection brief, therefore I have filed the Wakalatnama in CAN application. That may be ignored. And another, I have already submitted the fresh amended cost title. And
So what about the Wakalatnama? The additional stamp reporter has said you have not filed the Wakalatnama with the memo of appeal.
Lordship,
Have you filed it now?
Lordship, I have filed the Wakalatnama in the writ petition. Restoration application has been filed. That restoration application, I have filed no objection Wakalatnama, Lordship. Therefore, that may be ignored, Lordship.
So now file the fresh Wakalatnama. Have you seen this? What are we talking about?
Yes, Lordship. May I?
This defect
may I
have you
speak
removed?
as your Lordship direct? But as I have already filed in the writ petition, no need to file fresh Wakalatnama, Lordship. I am further engaged on behalf of the appellant before the appeal court also. Therefore, no Wakalatnama need to.
You have not filed with the memo of appeal.
Yes, Lordship.
That is the
But
stamp.
not in memo of appeal, Lordship. In the writ petition, restoration application has been filed. In that application, I have filed my Wakalatnama.
That is the Wakalatnama for the writ petition.
Yes,
Now, if you
Lordship.
still say we have to ask, then we are not passing any order
No,
today.
Lordship, then I have
We
to
will
file.
have to ask the additional stamp reporter to give a fresh report. That
Lordship.
is all that we can do. Unless and until you file a Wakalatnama in terms of the report given by the additional stamp report. Please see the report.
Yes, Lordship. I talk with the stamp reporter department, Lordship. They have advised, as I have already filed, no need to file, and I have to submit before your Lordship. That may be ignored.
Very well,
As
we'll
that
ask
has
for it.
already been mentioned, they cannot correct it. That may be ignored by your Lordships. They have advised me.
Good. If the stamp reporter has said so, let them say it before us. Because now another Etuboshu.
Neither I have to file fresh Wakalatnama. I have the Wakalatnama, Lordship. I have to file.
Now,
They have advised me. Therefore, I am not filing.
correct. Now look at what they have written to us. Etao dekho erpore. Upore patata. Now please see what the stamp reporter has written to us after what they have advised to you.
Regarding expunge of the appellant number 2 and
Done.
3.
Read this next paragraph.
This is submitted that learned advocate has expunged the names of the appellant number 2 and 3 from the array of the parties on 12th May. This is submitted further that the defects as noted by the additional staff reporter have not been removed till date. But they have advised me, Lordship, that I have to file the Wakalatnama, Lordship. I have prepared the Wakalatnama, I have to file. Wakalatnama to the kothay ache? No? They have advised, so I am not filed. মুখে এক কথা বলেছে আর
লিখে দিয়েছে আরেক
লিখেছে আরেক। মানে আমাদের ডিপার্টমেন্টে নিজে বলতো যে আপনি যেহেতু ওখানে
Very well. You do one thing. You file the Wakalatnama
Yes, Lordship. I have the Wakalatnama, I have to file.
and then file it, come back. We will hear you tomorrow.
Lordship,
We will get a report.
Yeah, Lordship, I have to file the
So
Wakalatnama.
stamp reporter has stamp reporter must tell us that your defect has been removed. We'll hear you day after tomorrow.
Lordship, according to their instruction, Lordship, I am not filed that.
What can be done? They should have been fair to you. They
For
should
the
have written.
technical ground, Lordship, the appellant was not allowed to do.
Now
the
you're making a
class
different
learning
submission.
post semester.
Madam, now you're making a different submission.
Lordship, kindly condone. I have to file.
Why we kindly condone? You are making a submission, stamp reporter has told you. If it has told you, it has told us something else.
That is
So we
different,
follow
Lordship.
this. We do not follow you because there is official instruction.
Findings of the-
No, madam, you stuck to your point when we were trying to tell you. Now we are sticking to your point when you are trying to tell us. So we'll meet day after tomorrow after the stamp reporter tells us the defect has been removed. You are entitled to stick to your point. No harm. No harm. We will stick to our point.
For the interest of the sake of the study of the.
Not at all now.
Lordship, I am
Well,
ready
survey,
to-
we will consider it on Thursday.
Lordship, not my ego problem, Lordship, only for the interest of the student's
Please,
career, Lordship.
come
I am
back. It is
submitting,
not
Lordship.
our problem.
I undertake to
Ashok.
file the wakalatnama, Lordship.
You file it, give
Yes,
us the
Lordship.
filing number day after tomorrow, we shall take it up.
Tomorrow, Lordship,
Party
not day
this-
after tomorrow, Lordship. Tomorrow I have.
Tomorrow.
Yes, Lordship.
Party this slash are represented in the order of their names slash names as printed above
In the same heading, Lordship.
full stop.
Let it up.
Para. Mrs. Patro Kamalan, counsel appearing for the appellant submits that the
ওকালতনামাটা সই করা ছিল বার করো না বাবা
correction
এটা
directed to be carried out by the previous order of this court dated 8th of May 2023 has been carried out
সই করা ছিল
and the names of the
আরে আমাকে কালকে 12 তারিখে বলো দিতে হবে না করতে বলো কি বলবো বলুন তো মুখে
appellants slash
ও তো হ্যাঁ
petitioner numbers 2 and 3 have been expunged from the cause title of the memorandum of appeal. Full stop. Para. Mrs. Patro further submits that the single appellant slash petitioner in MAT 768 of 2023 that on behalf of Koradin, the single appellant in MAT 768 of 2023, comma, an amended cause title has been filed, which we taken on record. Full stop. It is pointed out that a copy of the amended cause title has been also served on learned counsel appearing for the respondent slash university. Para. The appellant also further files affidavit of service, which be taken on record. Full stop. Para. Having para. However, comma, this court is now required to notice the report of the additional registrar, comma, report of the assistant registrar and the SO, comma, SR section and the SO, comma, SR section dated the 12th of May 2023 that other defects as reported by the additional stamp reporter are yet to be removed. Full stop. Para. In the light of the above facts, comma, the appellant is granted one more opportunity to remove the defect. And revert to this court on the next date. Full stop. Para. Accordingly, comma, let the matter be placed next under the same heading, mentioned matter tomorrow. That is ki tarikh poche 16th of May 2023.
But I'm sorry, Malay, I was late. I'm for the state, but actually the university is the.
No, we had there's no issue. There was no issue. There was one lady called Soni Kumari. She had an earlier order of this court on similar lines. She wanted an identical situation. Now there is a defect which still remains in the memos. Mrs. Patro submits the stamp reporter had advised her, no, this defect is removed because she had filed a vakalatnama in the writ petition. But we have shown her from the stamp reporter's report to her that that defect is not removed because there is no vakalatnama with the memo of appeal. So we were stuck at that point. She was stuck at her point. We were stuck at our stamp. We have given her an opportunity to remove that defect and come back to.
In course of detail.
আমাকে 12 তারিখেই বললেন আর করতে হবে না রিটে যেহেতু দেওয়া আছে আবার রেখে দিয়েছে
ঠিক আছে
বলছে আমরা রিমুভ করতে পারবো না কি অদ্ভুত
Doctor.
Lordship.
Exception is. My lord, I beg to appear for the appellants.
Yes, Mr. Basu.
My lord, on last occasion, your lordships, my lord, directed the respondent, my lord, state and oval, my lord, to serve, my lord, the report, my lord, in form of affidavit.
Ready, my lord.
Aadhaar card. I need to do something also. Aadhaar card can I-
Yes. Where are the reports?
My lord, may I file the affidavit, my lord? I appear for the scheme.
Lord, for respondent number 2, led by Mr. Ghosh. Lord, I have filed the exception. Education আমরা করেছিলাম ওই জানার জন্য। তাতে যখন আমরা acknowledgement দিয়েছি তখন আমরা ইউনিক আইডেন্টি আধার কার্ড দুটো দিয়েছি। এবার স্টেট ওটাকে যখন পাবলিশ করেছে আধার কার্ড, এখন আধার কার্ড ইজ স্পষ্ট করবো আইডেন্টিটি। পরীক্ষা দিয়েছি। The point is very short, my lord. প্যারাগ্রাফ 9 আমরা বলেছি, আমরা হাতে হাতেও দিয়েছি আর একটা ইমেলে গেছে। সেটা তো কি বলতো, সেটাই জানতে চেয়েছিল আমাদের। আধার কার্ড দুটোই একটা দুর্নীতি হয়েছে কোথায়? অ্যাপল লিখেছেন, অ্যাপল হ্যাঁ, নারে বুঝলি টেকনোলজি রেসপন্ডেন্ট নাম্বার 2 ভালো করে লিখে আটা দিব।
Please take your seats. Well, you have either the state has copied your affidavit or you have copied the state's affidavit.
No, I do not know, my lord.
That is as simple as that. And now if you come to the exception, Mr. Ghosh, page 4 of their exception, how do you respond to paragraph 2? They say, have you seen paragraph 2
That I have received a copy.
of the exception?
The card exception.
The Aadhaar card number.
The thing is this, my lord, there are two: identification and Aadhaar card. We have given them the Aadhaar card number, the government. Now, if he says that you give the identification, we shall give.
Yes, we need the unique
Acha to.
identification number.
Ah,
We need an illustrative merit list, not 60,000 candidates. We need the merit list because they say Aadhaar card, as they have said in
I have to, because of easier identification, I have used the Aadhaar card.
no, for the merit list.
Using of Aadhaar card, this does not show that there was a dishonesty going on.
Whether
Here
they
allegation of dishonesty we will not do.
No, we need the unique, yes.
My lord, only my lord, the main point in this report by my learned senior, my lord, the best possible identity for a person that has been used in the Aadhaar card. But not, my lord, it is the best possibility identity for a candidate registered. That is my point.
Whether the person in the merit list holding the Aadhaar card number was a registered candidate with Webble when he applied.
They don't say that he is not registered. When I come to the court, I have to say that this man has not been registered. He has to make certain allegations. No such allegation.
You can give an illustrative list. Let them respond to it. Give us a page. Do not give us the full result. Give us a page showing that this is the Aadhaar card.
I shall give their names, identification.
The unique identification number against the final merit list.
And along with the KO.
Yes, we'll say you please respond, clarify this part of the order in your affidavit. That is all.
Which one, my lord?
This
part.
Page 4, paragraph 2. We'll state that in our order. You please clarify in your own way before them. Let them also file. We finish the matter off. Yes, that is, Mr. Basu. Let them clarify. Give an affidavit, further affidavit to you. You just have a look at it and then.
Because, my lord, one thing also, my lord, I just draw your lordship's kind attention. My lord, the 13th of August, 2021, the last, my lord, the interview has been, my lord, completed at, my lord, 5 p.m. And, my lord, within, my lord, 1 hour, 6 p.m., the entire, my lord, the result has been published. My lord, what kind of method, what kind of, my lord, manpower has been used? That is, my lord, only the questions.
Yes.
Lord, we'll also respond to that. We'll respond
When
to that.
when they applied, Mr. Ghosh,
In the writ petition, it was not there. Every day there's development. That time I was asking my junior.
Maybe not.
Every day there will be a development. When I come to the court as a respondent, I look at the prayer and the grounds and where the statement has been made. Thereafter, the moment I answer, I have my answer. It starts rolling and getting wider.
What were the parameters of selection? How was the selection to take place?
My lord, it is completely, my lord, not specified. Only just, my lord, called for interview.
Correct.
My lord, one question has been, my lord, just asked, my lord.
And then where you
my lord, just raised hands and, my lord, just give the answer. That is the main. Nothing.
Now we are interested in the unique identification.
My lord.
And they have not annexed the writ petition in the appeal. They have not even annexed the writ petition.
My lord, I have, my lord, already, my lord, this made the exception in against, my lord, this report. My lord, another thing is that, my lord, in their, my lord, the report, my lord, the state has, my lord, prayed before your lordships for expansion from this appeal. My lord,
only one department of the state. You have not read that correctly.
Well, that has not been raised in the trial judge.
The only one department, the other department has responded. It's not that there is a complete expansion. Anyway, you respond to paragraph 2 of this. Once we have the unique identification number, give your merit list. Produce a merit list.
In the meantime, my lord, subject to his lordship approval, let this Department for Personal and Administrative Reforms made a party so that my lord,
Yes.
I can directly talk with them and
Mr. Supriya Ranjan Shahab, you are the counsel assisting Mr. Ghosh. You produce your merit list.
Yes, my lord.
You need not file another affidavit. Produce the merit list in original with the unique identification numbers.
The original we have sent to the.
You have a copy?
I have a copy.
You have to produce an address, but provide the unique identification of the successful, what you have sent to them. You produce that on the next date. And you need not even write an affidavit now. We'll show them, they will be, you show it to them, there will be a disclosure. You let them see the document and then you come back to this court with it.
No, the difficulty is this, when a nowadays I am finding, well, I am wrong probably. Writ petition is started on one premise.
Correct.
And then it goes on.
We are not taking cognizance. You're right. We are not taking cognizance of the 5 p.m., 6 p.m. story.
For
Right
that reason, we come to your lordship.
That is why we wanted to know what was the methodology. It may have been that the typing test was over. The interview tests were added. It did not take time to, but we are on the unique identification number because the complete identity of the merit list should be. Ashwin. Parties / are represented in the order of their names / names as printed above in the cause title. Full stop. Para. In terms of the previous previous order of this court dated the 10th of April 2023. Reports are respectively filed by the state respondents and for Hon'ble Technology Limited, all capital, also a respondent. Full stop. Exception to the said report is appellant / the writ petitioners. Full stop. Para. While the report filed by the state respondents and Hon'ble Technology Limited make identical statements, attention of this court is drawn to the following paragraph in the exception taken by the appellant / petitioners. Full stop. The paragraph number 6 reads as follows. Paragraph 6 exception. Full stop. Para. The state respondents are permitted to respond on the next date on the basis of the original record their clarification to paragraph 6 within bracket supra. Full stop. The original record should the state the Hon'ble Technology, the Hon'ble Technology is permitted to respond. Hon'ble Technology is also permitted to respond. Also permitted to disclose a unique identification number, UID, of each of the candidates in the merit list against their original application forms. Full stop. Prior to production of the original records before this, court on the next date, the learned advocate for Hon'ble Technology Limited shall disclose the documents to learned advocate for the appellants, who shall take inspection of the same.
My lord, they have not challenged it before, my lord. After he failed, Then he took all these points.
Maybe. We are on a point of identity. We intend to keep the point of identity alive. Disclose the documents before the Learned Council for the appellants. Who shall take inspection of the same? Full stop. Let the matter return under the same heading mentioned matters by date at a date.
My lord, so far we take.
We'll expunge. Under the same heading mentioned matters on the 8th of June 2023. Full stop. From the report of the state respondents, it transpires that the Department of
my lord, Personal and Administrative Reforms
instead of
my lord, Department of Information Technology and Electronics.
that the Department of Personal and Administrative Reforms be added as a party respondent to the appeal. Let the other remain.
Let it
Full stop.
Come on 14th or 15th June, my lord.
Yes.
Let it come on 14th or 15th June, not on.
The data. Yes.
আরে তারপর ফিরে তো আসা সম্ভব না।
14th June. 40 mentioned matter on 14th June. We added as party. Let Mr. Subrata Learned Senior Counsel appearing for the state respondents takes notice on behalf of the added respondents. Let additional copies of the appeal and stay application, if necessary, be served on Mr. Busumulli in the course of this week. All parties to it.
My lord, may I? My lord, in the morning, two matters were mentioned before your lordship. Your lordship was pleased to fix a date regarding the one order. Mr.
Sarkar is also here. Your lordship, my lord, it was a pleasure of your lordship, my lord, to fix a date, my lord, subject to convenience of the council for the parties. In the morning, my lord, your lordship, my lord, granted leave, my lord, to file appeal, my lord, that challenging the.
No, already, my lord, I have handed over the, my lord, mentioning sleep, my lord.
And what I am praying, my lord, kindly fix him, my lord, day after tomorrow. Thursday. What I am submitting,
Lord, I am opposing, my lord.
Kindly fix it on Thursday.
My lord, urgency, my lord. I
Today the
cannot
matter
wait,
was
my lord,
mentioned
till
before the
Thursday, my lord.
Today the matter was mentioned before the honorable single judge. But there are some for corrections.
Yes.
The matter will appear
My lord, I
tomorrow.
gave your lordship, my lord, correction is, my lord, 36,000 to 30,000.
Yes.
When will it appear, Mr. 1 minute? Let us relax.
Yes.
When will the matter appear before the single?
Tomorrow.
What time?
Tomorrow, 10:30.
Very well. Tentatively, you come back and consult our court officer. We'll be taking up tomorrow. There's a bench with me with another honorable judge at 2 p.m. Tentatively, we have decided to take up this matter at 3 p.m. tomorrow. Whatever is the position, come and inform us.
My lord,
May I submit, instead of tomorrow, my lord, can it be on day after tomorrow?
It is second half, there is an original side. That is the difficulty. And on Thursday, we are too close to the vacation.
Day after tomorrow morning, my lord. Tomorrow
Morning, there are fixed matters. If there's any difficulty tomorrow, it will be day after tomorrow morning. We assure you, we will not create a situation where everybody, but we intend to take it up. Please ask your consult a court officer, because I have to speak to my brother judge, who has a bench at 2 p.m. with me tomorrow. And then we reassemble for that matter fixed at 3 p.m. If there's any difficulty, we will spill over the argument today after.
My lord.
So tentatively, it is, we give our mind, confirmation will come through our court officer, Mr. Tiwari, Mr. Biswas, 3 p.m. tomorrow fixed matter.
My lord, deeply obliged, my lord, grateful, my lord.